Yeah, please.
Yes.
I'm very sorry, my lord. In the morning, I'm making such a prayer, my lord. Well, my senior, Mr. V.K. Mahajan, my lord, recently underwent, my lord, cataract surgery, my lord.
Who, Mr.
Mr. V.K. Mahajan, my lord, my senior, my lord.
V.K. Mahajan for
For the appellant, my lord.
Appellant.
His name is not there, but he's leading me, my lord. Recently under cataract surgery, my lord. And he did not follow doctor's prescription, my lord. He was supposed to wear the eyeglass for 7 days, my lord. Again, the redness and swelling has come. Otherwise, I'm prepared, my lord. But
you are prepared.
but my senior was supposed to appear, my lord. I could not brief him because of if lordship grants a week's time, my lord.
So, Mr. What is your name?
My name is N. Mahajan, my lord. I'm appearing Mr. P.K. Dust.
Mr.
N. Mahajan.
N. Mahajan appearing for the appellate submits that Mr.
B.K. Mahajan, my lord.
V.K. Mahajan is to, he is a senior counsel.
Not designated.
Not designated senior counsel, my lord.
Then how can he appear without his name not being in the Vakalatnama?
My lord.
Who has given him the authority to appear? Huh?
We'll take a new Vakalatnama, my lord. Then from the client's, my lord.
Submits that Mr. B.K. Mahajan. Why? Because of the bad case or what?
No, my lord. I'm otherwise bad case, my lord. I'm otherwise prepared, my lord.
Bad case. It's a bad case for you.
I'm otherwise prepared, my lord. I'm praying for only conversion, my lord.
Submits that Mr. B.K. Mahajan will be leading in this case and he will be filing Vakalatnama within 2 days. He
2 days, my lord,
submits,
they'll come from.
he submits that Mr. B.K. Mahajan is presently having a cataract surgery.
In the last week, my lord, he had cataract surgery.
Submits that Mr. B.K. Mahajan had a cataract surgery in the last week and needs another week's time to rest. Miss S. Jahan, additional PP, and Mr.
U. Chaudhary for the informant.
U. Chaudhary for the informant appear and submit that they do not have any objection. List the matter after review.
2017 matter, sir?
2017.
After a week or so?
After it,
Week.
List the matter after review.
my lord, another humble prayer, my lord. 2 days, my lord. It can be 5 days, my lord. They'll come from
Okay, within 5 days. Huh?
5 days. Obliged, my lord.
There are eyewitnesses here.
Yes.
My lord.
Huh?
Confessional
My lord,
statement.
otherwise, I would be on.
Not only that, your first wife has also seen it.
Yes.
Only
Confessional
conversion.
statements.
First
are-
wife has seen it, second wife has seen it.
Confessional statement.
Confessional statement is there.
Yes, my lord.
He said he'll try
Only
for a
for conversion, my
conversion
lord. Otherwise, I would have paid.
from 302 to 4.
My lord. Obliged, my lord. Thank you.
Is a date required to be fixed? Only.
Up to your lordship. Not-
When do you want? Which date? You will fix a date.
Any after a week, my lord.
After
So,
a week,
14th?
next Thursday also, next Friday also. What?
Yes, 15, 16, any
Monday.
day.
Thank you.
Aji, not eh?
Bring that closer. I can't see that.
18 months.
16, 17, and 20.
18 months.
21st, my lord.
21st.
List the matter on 21st.
21st. Gotcha.
Highly obliged.
I don't know. Oh, I don't know.
Mr. Das otherwise appears he's regular to the court, but today I don't know what has happened.
To do.
Item number 3, council is ready. By the
Okay.
time 2 council.
What about
might-
this item 4 hearing also is there?
4 is otherwise parted.
Is it Pathak? No, we didn't.
No,
put it as
lordship has
Pathak.
heard it on
Oh, we
Monday.
heard it.
Ah.
But why is it in the hearing list? It's supposed to be admission or what? Hearing.
Oh, that I. Perhaps the final disposal, so it's written like that.
Okay, right. No one appears for the learned amicus curiae is absent. While the additional PP is present. List the matter after review.
Correct, I'm appearing as amicus in this matter.
Yeah, amicus.
Amicus, excuse me. And
Huh?
at the very beginning, I find it little difficult case because there are 3 eyewitnesses to the murder.
And one is one has got nothing to do with any of them.
One is the son And one eyewitness is the son, one is the wife, and that one is
Then one in the field
individual
who saw it from far away.
far away. Take your lordship. I'll take your lordship to the FIR first.
Yeah.
Page 4 of the paper book. FIR was lodged after on the next day of the incident.
Okay. Page 4.
Page 4.
Dated
It's dated 30/7/2013. And the incident occurred on 29/7/2013.
incident occurred on
29/7/2013.
okay.
May I just phone FIR? Just read that FIR. I beg to state that at about 7 o'clock in the morning yesterday, as my father went out from home on his bicycle to Lalchera Mukai in order to get his mobile phone charged, the aforesaid accused person waylaid my father in the front of the accused person's house and started hacking my father with a sharp dowel. As a result of the accused person's assault, my father fell down on the ground and started screaming. Hearing his scream, a lot of people, both male and female, arrived at the spot. And on receiving the news, we too came from home and immediately took my father to Silchar Medical College and hospital. My father died while under treatment there. We stated that we have long-standing land-related dispute with the accused
So
person.
the informant is the son.
His informant is the son.
And is this son the eyewitness?
Yes,
Huh?
yes. But another person who is a co-villager, he became hostile, PW1,
He became?
hostile witness.
Okay.
Your lordship will find at page 9.
PW1.
PW1, his name is Bipin Roy. On oath, he says, I know informant Sanjay Rai, who is my co-villager. His father, Jayanta Roy, was also known to me. Also, I know accused Badal Gwala, who is my co-villager. Incident occurred about 2-3 years ago in the morning. At that time, I was cultivating my land situated southern side of my homestead. On hearing hue and cry, which came from the northern side, I went to the PO and found Jayantaro is lying on the khet land in injured condition. There were other persons at the place of occurrence. I found Manik Roy, Parimal Roy, Nirobala Roy, and others. However, I did not see accused Badal at the place of occurrence. So at this stage, the witness was declared hostile on verbal prayer of the learned PP, and he was cross-examined by the prosecution. It is a fact that I stated before the IO that I saw Badal Gwala with a dao in his hand going towards the house, towards his house. It is not a fact that I stated before police that I could not know accused Badal Gwala for scolding him struck blows by means of dao. Then at the defense cross-examination, he says again, I did not see any incident. I cannot say who raised hue and cry. I did not state before the police that I found Manikra Punimal Loy and Nirobala at the PO. I did not ask anyone about the incident. So his testimony is a little bit dicey. So even if we don't take his testimony, but the eyewitnesses, the lordship will find the first eyewitness, his son, PW2,
Yes.
page 11 of the paper book. He says on oath, about 4 years back in the morning at around 7 a.m., while my father was going to a nearby shop to charge his mobile, on the way when my father reached near the house of the accused Badal Gwala, at that time, accused Badal Gwala restrained my father and gave consecutive dao blows on his head, right shoulder, and face. As a result, he fell down on the ground and hearing his hue and cry, the neighboring people gathered there and I also came to the place of occurrence, hearing the hue and cry of my father, and my mother also followed me up to the place of occurrence. I personally saw the occurrence. Thereafter, we rushed to the Lala PS, taking my injured father, wherefrom my father was referred to Lala PHC, and from Lala PHC, my father was shifted to Civil Hospital, Hailakandi, and considering the serious condition, my father was referred to SMCH Silchar, wherein my father died during treatment. The post-mortem examination was also held at SMCH Silchar. On 30/7/2013, I lodged the FIR, Ejahar, Exhibit 1 in respect of the incident at Bilaipur OP, wherein Exhibit 1 is my signature. Thereafter, the case was transferred to Lala PS Police, recorded my statement during investigation. Then the defense side tried to some confusion regarding the dates. So they put the question to the witness. I cannot recollect the date of incident. On the date of incident itself, I lodged the FIR. But it's clear.
You see, his statement is that scuffling took place between him and the accused.
Yeah,
I mean, it's
it's clear because
It's clear.
on the date of occurrence, he took his father to the hospital, which is in Hailakandi district, which falls in Hailakandi district.
and they're neighbors, it appears. Huh?
It appears they're
They're neighbors because it is the east of their house.
Yeah. So on the next day, after coming from Silchar, they lost the affair. Nothing discrepancy is there. And at the time of incident, he was
Scuffling took place between me and the accused. The 1, 2, 3, 4, 5, 6, 7, 7 lines. Seeing my father. There is Halla and there is Halla. The accused inflicted blow on the face of my father, and at that time I tried to save him but could not. And as a result, scuffling took place between me and the accused. What more do you want? Then what else? Besides this?
his age was 12 years at that.
Huh?
His age was 12 years at that
This
at
boy.
the time of
This
incident.
witness.
This
So what
witness.
is wrong?
Nothing. And the
Child witness, 12 years.
And the other eyewitness, his wife, the victim's wife, she is PW3. She says, I know the accused Badal Gwala, the deceased Jayanta Roy is my husband. The informant Sanjay Roy is my eldest son. The incident took place about 4 years back. On the relevant day at about 7 a.m. while I was in my house, on hearing hue and cry of my husband, I ran towards the husband and saw the accused person Badal Gwala inflicting thou blows on my husband on the MNREGA. It's probably on the road. Nearby my house.
Yes.
So this is the
You see
eyewitness.
out
And
here also. I went to resist the accused, but he pushed me on the ground
Yes,
and inflicted
she
a
was
kick on
also
me.
she was also got injured.
Very clear.
Very clear case, madam.
Very clear case. Clear cut case.
And during cross
And the
examination,
funny part is, I'd say early in the morning, it's 7 a.m. I can understand in the evening after he's had a few drinks
exactly.
or something like that, some problem. But
There must be some
usually at
previous-
7 a.m. people are,
Fresh mind,
fresh mind, clear as daylight.
and moreover, they say there are a lot of people who
Lot
came
of
to.
people.
And the third witness, eyewitness, he is also independent eyewitness.
Was working in the field.
He was working in the field. I'll take your lordship to
Yes, that's what, that makes it
7.
more than reliable.
more than reliable. Yes, PW
Page number?
page 18, PW7.
Who is PW4?
PW4 he doesn't know anything.
Okay.
4 and 5.
4 and 5 is
4
nothing.
and 5, 5 is a petition writer who wrote the Ejahat,
Okay, and 6,
and 6,
He accompanied the injured to the
hospital.
yes,
hospital as well as the police station.
So,
Yes.
so PW7
Huh.
is the eyewitness.
Yes.
PW7 is the eyewitness.
He's a
Independent.
farmer.
He's a farmer,
Independent eyewitness.
independent eyewitness. There only one thing which clicks in mind.
Slipped. Initially, he slipped and he was.
Well, probably he was pushed and he slipped. Then I know the accused Badal Goala. I know the deceased and the informant. About 2 years of the incident. The years are something because in 2018 they are saying 2 years back the incident.
2
took place.
months, it should be 2 months, I think, no?
You see,
It
the
should-
problem is we have to compare this sometimes with the vernacular.
Exactly. That's why I checked it up.
But this is
But it's
original.
typed copy. This is the
Yes,
original.
This is
Okay.
the original.
This is
It's
original.
signed.
This is the original.
Okay, anyway, how does it matter?
Mm.
Oh.
Then I saw from one Kedar distance. What is Kedar?
Yeah, that's a question that put in my mind. So I called up some lawyer in Barak Valley. There, there's a system of measuring the area in the village area. They usually follow the measurement which was done in East Pakistan. So they used to make Justi. Katha is also there. Then Bigha is also there. Sometimes Kedar is also there. So I asked, what is 1 care? They also say it's care or Kedar.
So how far is what is the
So
length?
what they say me that this
Kedar.
28 Justi equals to 1 Katha, 1 Kedar.
20 Justi, and how much is one Justi?
1 Justi is 441 square feet.
And that is square feet.
Yes,
that
they
is the
done-
area. That
it's
is
an
the length.
area, square feet. This is 1 Kedar. I found it. It's around 1029 feet away.
No. You cannot look at it that way. You see. Now supposing there is a plot of land, 4 by 4, say, or 4 by 5,
Yes,
4 feet by 5 feet, plot of land. The area of that land will be 4 into 5, 20. So you cannot say that the length of that land is 20 feet. It is not.
no.
The
may
length
not
of
be,
the land
may not
might be 5 feet only, but the area is 20. So when you say one Kedar is
be. It's
400,
difficult to find out.
so you don't know.
But
You have to
perhaps-
see the length.
Perhaps my lord is aware about that. That in Barak Valley, the people usually say it's a 1 km distance only. So it's nothing like that 1 kilometer. It indicates a
Area.
area of land.
Anyway, it's basically whether it's one Kedar distance or anything. Is there,
But he saw.
is there any cross
But
examination?
no cross examination was
To
done
that
on that point. So we can rely on that. In front of a small house belonging to one Tinku, Jayantara fell down on the ground due to slippery ground, and then the accused inflicted down blow on him. Then in cross examination also nothing has come regarding the distance and all. Jayantara was proceeding through a small path, and then due to slippery path he fell down on the paddy field. The path belongs to Monilan. When the accused inflicted the injury, many people gathered there, but I cannot say their names. So he also, in cross-examination also, he said that the accused person inflicted injury. And he saw it. Now, nothing I could found from the IO, but the medical officer confirmed the injuries, which your lordship will find at page 22.
PW number
PW number 9,
9 is the doctor.
doctor.
So what is page 22?
Page 22.
What is his opinion?
On examination, just may I read?
Yes.
There's 3 points, 4 points. On examination, I found a male body of average dark build, dark brown complexion, rigor mortis present with closed eyes and mouth injuries. Cut injury over the head extending from the bolt of the skull of right side up to the frontal muscle angle
No,
with
no, it's okay.
forehead
It's
cutting.
very clear. Page 20.
Very clear.
Then,
Then the cut injury angle on the mouth measuring 7 centimeter.
I think this is
That is
enough.
also,
Next.
every injuries are very clear. Cut injury over right shoulder,
Opinion is also due to a weapon.
weapon.
Now, was the weapon recovered? Is it seized?
No.
No, that is probably not seized. I have not seen that.
What is this? Why is the weapon not being seized?
There is a seizure list for 60.
With this, I have not seen
No,
the
it is seized.
Where?
lip 7.
Page number 61.
60,
Page 61.
yes, 61.
It's a tangy
Was it
down.
exhibited? What is it? Was it
Ha ha ha,
exhibited?
it's exhibited 7. Exhibit 7.
What it is a Dow?
It's a
One
10.
Tangol down.
Tangle down.
That's probably their local language.
Okay, and
Yes,
it's Dow.
Hailakandi, no?
Dow, it is, what is the exhibit 7?
Yes.
Exhibit
It's a page.
Material exhibit or exhibit?
It's an exhibit.
Only exhibit,
Huh.
no material exhibit.
No material exhibit.
So it's a exhibit 7.
The Caesar list only, not the Dow.
Oh. Okay, anyway, so it has been seized.
Huh.
Then what remained?
As far as the homicidal death committed by this person, it's established more or less by 3 witnesses. But whether it can be at all converted and all that
Let
also,
us
I
see
don't find.
313. Let us see 313.
313.
313 he denied. He
He
said
denied it.
false.
He denied.
Huh,
Denial
simply.
is,
I do not know.
blank
that.
denial does not help.
Mm,
Because according to the evidence that has been adduced,
mm.
the court has got inherent power to,
Exactly.
to impute.
Only that there was something in between them. There was a quarrel,
Property dispute. it is.
property dispute.
It-
2 months back also, one said that they were staying in Nagaland and there was a.
But no justification for killing
Mm,
unless
And that too at 7 of
at
7
7 o'clock in the morning when they're supposed to have chai. And there's no evidence that they were drinking liquor or suddenly in the heat of
nothing.
anger.
No provocation and all. I don't find any of the clauses.
It appears that there was a motive.
There is a previous motive.
Appears.
And they were working together also, one of the witness said, at one point of time.
That's all. Let
Difficult.
us see 313 is at page 26.
Yes. I do not know. It's only that. And he simply said, I'm innocent. I have been falsely implicated.
That's all.
That's all. He did not adduce any evidence.
And hearing of accused on point of sentence, he says, I have got a big family comprising my wife, children, and I am the sole.
Those are normal. Just
Those are
Normal.
normal things.
okay. So judgment and order was pronounced when
It was pronounced on
27/9.
27/9/2019.
27/9/19. Convicted under 302.
302 and
And 341 again,
41.
What is 341?
a restraint, I think, no? 341 9 again? No, he was charged under 341,
Charged
but
under
conviction
341.
only under
And
301.
Charges were framed only under 302 or 341 also.
charge was
Both.
framed
Two heads.
302 and 341,
41.
but he has been convicted under
Convicted only
302.
under 302.
Mm.
And sentence order was passed when?
Same day,
Same day.
Same day.
27.
In one order or separate order?
One order.
One order. Lordship will find at page 41.
That whether that will be correct. Usually some time at least is given for sentencing.
But then the hearing on sentence was done
On
on
27/9,
27/9 that day itself. And immediately thereafter, he must have pronounced.
No, but usually sentence, I think you have to give some time, no?
usually,
No, there is no requirement as such in the
Are you sure?
CRPC.
Are you sure? No, by judgments of the court.
Ah,
by
acha,
Supreme
judgments
Court.
of the court. In some cases, it is done when the hearing takes place little later on the sentence. But since the hearing was on the same day,
Should not be usually.
after having heard paragraph 29, the judge said, he has been given 5 hours time for sentence hearing.
Okay, that's what I'm saying. Time has been
Yes,
given.
5 hours time.
Then it's
Paragraph
okay.
28. it says.
28.
Okay.
Heard the accused and learned on the point of sentence.
Because if time is not given, then there is a luck.
5 hours
Ah.
was given.
That's all?
Nothing much, so it cannot be interfered.
Anything else? Nothing?
Nothing.
What is the fees of thing?
I think it's 7,500 and 8,500.
I never got.
In Aizol bench, before the division, it's 8,500.
Acha, acha. So same will be
That is
here.
what is, huh? Same here.
Even I am confused of 7 or 8,500.
8,500 for the division bench.
7,500.
And before single bench, it's usually 7,500.
Oh. It should be enhanced in a way here.
Depends
That's
upon the amount of work you need to be done.
And
In some
the-
cases, you don't have to say anything.
There, of course,
It
it
depends
depends on
upon
the
the case to
Yes.
case, because here I didn't find anything which can be pointed out to your lordship.
Which could really, have racked your brains.
Exactly. In some cases, we have,
You have got to apply your mind and
Yes.
do this. Okay, clear cut.
it's a clear cut case.
Even sometimes eyewitnesses needs to be seen with a very close angle, whether it can at all be believed. Here, what I see is PW2, the son. He was not there with the father. He heard hue and cry and then he rushed
Yes,
from his house.
yes.
By that time, he was already hit.
No, but then
But
you
then,
see, you see,
yes,
you see, you
that
see,
was
there is-
continuing.
you see, There is one thing. He's not been hit once
Hmm.
by the dove.
Thrice
He's been
before.
hit a number of times
He
by the
was
dove. That's why
continuing.
there are so many cuts and bruises.
Hmm.
So, and you see, it's not that when you hit with the dove,
Yes.
within 5 seconds, it's finished. Nothing like
Nothing
that.
like that.
You hit, then he'll dodge a little bit. So,
Then again.
so it takes time. It takes a lot of time.
Hmm. And the house of Badal Gwala's sketch map, if the lordship sees, sketch map of Badal Gwala got to defasen.
Oh, very
I
close.
think we have heard.
They are neighbors.
Sketch map, Badal Gwala's house is, oh yes, it's shown. C indicates Badal Gwala's house. And the Heri naam ki deceased on
He was Roy.
what, right?
Roy.
Okay, right. Third, Mr.
Is her.
Edhar, learned counsel for the learned amicus curiae appearing for the appellant. While Miss S. Jahan,
Not yet. Jahan
additional
got to
PP
decline
appears for the state. This appeal has been filed against the
Oh, Sanjay
judgment
Roy.
and order dated 27/9/2019
Sanjay Roy लिखवाना है.
passed by the Sessions Court, Hailakandi. Sessions case number 69/2016. Arising out of what PS case?
Hmm.
My lord.
Arising out of yes, case DNA.
This is Lala PS case number 145,
Arising out of Lala PS case number
145 of 2013.
145 of 2013, by which the appellant has been convicted under section 302 IPC and sentenced to undergo
Page 41.
sentenced to undergo rigorous life imprisonment and to pay a fine of rupees 5,000 in default, rigorous imprisonment for 2 months. The facts of the case in brief is that, this is the prosecution case in brief is that PW number 2, who is the son of the deceased, submitted a complaint, submitted an FIR before the Dilaipur Police Outpost, Lala Police Station on 30/7/2030, stating that the appellant had waylaid his father in front of the appellant's house and had started hacking his father with a sharp dowel. Hearing his screams, a lot of people arrived at the place of occurrence. The complainant thereafter took his father to Silchar Medical College and Hospital, where his father died due to the death while under treatment. Consequent to the FIR, Lala PS case number. What is it? PS case number 145.
145.
145 of 2013
13 was registered under
was
section
registered under section 302
341, 302.
341/302 IPC.
IPC.
After the charge sheet was filed, wherein a prima facie case was found against the appellant under section 341/302 IPC. Two charges were framed against the appellant by the learned trial court under section 341/302 IPC. Next part. As the appellant had pleaded not guilty to the charges framed against him, the trial of the petitioner, the trial of the appellant started in the sessions court, Alakan. During the trial, 11 prosecution witnesses were examined. Thereafter, examination of the accused was done under section 313 CRPC. Wherein the appellant, wherever I say accused, make it appellant, wherever the appellant, where the appellant denied all the questions, denied all the evidence put to him in the questions under section 313 CRPC. Thereafter, the learned trial court found a prima facie case, came to a finding that the appellant was guilty of the charge under section 302 IPC and accordingly convicted him by the impugned judgment and order dated 27/9/2019. After giving 5 hours time for sentence hearing, for hearing on the sentence, the learned trial court sentenced the appellant to undergo rigorous imprisonment for life with a fine of rupees 10,000. In default,
5,000.
5,000. In default, RI for
2 years, 2 months.
Huh?
2 months.
2 months. Two months. Next paragraph. The learned amicus curiae submits. No, fairly submits. Should I say that? Submits at the outset that there are 3 eyewitnesses to the crime who have been examined by the learned trial. The 3 eyewitnesses are PW number 2, who is the son of the deceased, PW number 3, who is the wife of the deceased, and PW number 7, who is an independent eyewitness. He submits that the evidence of PW number 9, who is the doctor who examined the dead body of the deceased, the death of the deceased was caused due to a hemorrhagic shock following injuries which were recorded in the post-mortem report exhibited at EXT post-op 3, and that the same had been caused by a heavy sharp cutting weapon. Then what else? Anything else to say besides that? Nothing to say. So he submits that the submit that in view of the evidence of the eyewitnesses, he has got nothing more to say except nothing more to comment in this case. That's all. Yes. Ms. S. Jahan Bennett, additional PP, appearing for the state submits that the fact that the complainant's father had been killed by being hit numerous times by a dowel from a dowel used by the appellant, and which has been corroborated by the evidence of 3 eyewitnesses, the fact of the appellant being guilty of the crime under section of the offense under section 302 has been proved. She also submits that the evidence of the doctor clearly shows that death had occurred due to the injuries sustained by the deceased on being hit by a dog. Accordingly, the impugned judgment and order should not be interfered with. That's all. Nothing else to say. I think no, nothing else. Right. We have heard the learned counsels for the parties. The evidence of PW number 1, PW number 2, who is the son of the deceased clearly states that the appellant had restrained his father and gave his father consecutive dow blows on his head, right shoulder and face. Hearing his cry, neighboring people gathered there, and he also came to the place of occurrence. PW2 thereafter submits that he had personally seen the occurrence, and in his cross-examination has also stated that he tried to save his father but could not do so, and that a scuffle had taken place between PW number 2 and the appellant. PW2 was 12 years old at the time of the attack. However, no, first of all, just let's say first up on considering the evidence given by PW number. We do not find. We find that the evidence given by PW to the effect that the response to the effect that the appellant had inflicted continuous dow blows on the deceased has not been shaken. Next part. PW number 3, who is the wife of the deceased, stated that she saw the appellant inflicting dow blows on her husband near her house. When she went to resist the appellant, the appellant pushed her to the ground and kicked her. She was apparently around 10 months pregnant at that time. 10 months. Now, the evidence states that she was 10 months pregnant at that time, and she gave birth to a female child 3 days later. Not a female child, it's a girl child, 3 days. The evidence of PW number 7, who is an independent eyewitness, is to the effect that he was cultivating his paddy land when he saw the deceased fall to the ground and the appellant inflicting dow blow upon the deceased. First time. The cross-examination of PW number 3 and 7 also does not indicate that their evidence was shaken during cross-examination. The evidence of PW number 8 who is the IO? Is the IO? 8
8 is the, yes. Inquest, 8 is inquest.
No,
Is the one with
PW number
10 is the IO.
10.
10, no, 11.
11.
11 है क्या? 11.
11 with the eye of the
10
case.
is ये file के charge.
This could be a filter. No need, don't put that. No need. I don't. This no need to mention it.
No, yes.
The evidence of PW number 7, number 9, that is the doctor, is to the following effect. You just take page 22 from here to here. Okay, 21 and 22. The evidence given by the doctor, PW number 9, clearly corroborates the evidence of the eyewitnesses, which is to the effect that the deceased had suffered injuries due to a sharp cutting weapon, and which was the cause of the death of the deceased. Next paragraph. The dao which was used by the appellant was also seized by the police, and the same was exhibited as EXT-7 during exhibit 7 during the trial. First one. Next part. The examination of the appellant under section 313 shows that appellant has given a blanket denial to all the questions put to him. Next part. In view of the evidence of the eyewitnesses and the fact that the weapon used had been seized by the police, we do not find any infirmity with the decision of the learned trial court in convicting the appellant under section 302 IPC. Further, in the case of Raj Kumar versus State of UP, 2014 5 SCC 353, the apex court has held that in the event of complete denial / silence in respect of questions put to an accused under section 313 CRPC, the court would be entitled to draw an inference, including an adverse inference against the accused. In the present case, the eyewitnesses have clearly proved the fact that they have seen the offense committed by the appellant before their very eyes. And in that way of the matter, we do not find any ground to interfere with the impugned judgment and order dated 20/08/2000, no, dated 27/9/2019, passed by the learned Sessions Court, Hailakandi, in section case number 69/2016. The appeal is accordingly dismissed. Next para, in view of the, in appreciation of the assistance provided by the learned amicus curiae, his fees fixed at rupees 8,500, which should be paid by the State Legal Service Authority. LCR return to LCR.
Obliged.
So let my senior be competent, my lord. Mr. Goswami also in legs mining court number 12, my lord. He is coming, my lord.
So we'll wait over. They are the petitioner in our case actually.
I know. They had started, we had started with on Monday.
My lord.
They had already started.
Yeah. So can I do?
think we
my
have
part?
heard him out.
Yeah, absolutely.
No,
I'll
your turn.
start, my lord. But actually they were the petitioner, so I thought I'll take the permission, my lord, to start with it.
Okay. No, no. Just to recapitulate.
Yeah.
Basically, I think the issue is whether the criminal court under section 451, 457 can give custody of a seized property during the investigation.
Absolutely.
That is the long and short of it.
That's a one issue only, my lord.
One issue. Now they have given us various judgments, and on a reading of section 451, it appears to us that in 451, during investigation, court does not have the power to give custody.
According to them, as we have heard
Prima
it-
facie.
No,
Prima facie.
what I could guess, because on that assumption, I'll be only submitting, my lord. The learned petitioner's submission was that during investigation stage, there is no provision to give in custody at all.
Under 451 or 457?
457 also.
So let us go
chapter 32 does not
one
have-
by one.
Yes,
Let us
yes.
one by one.
So,
Now, let us go firstly with respect to 451.
yes, ma'am.
Now, their case, though, we know. Now, is it your case that under 451, it can be given?
Yes,
even
my
in
lord. Because
investigation stage?
451 and 457 have got only one difference, my lord. Produced and not produced the property.
But then it also, there is the word of the inquiry and
Inquiry,
trial.
yes.
Inquiry and trial is
Absolutely.
used.
No, yeah, you're all absolutely correct. Because
So-
like, before that, I think we should go to section 100 from where it starts. But because once the FIR is filed, because here we are dealing with a police case investigation, not like the complaint cases filed by the DRI or drug inspector or something like that. So that's totally different footing, my lord. When a complaint case is filed by the government officer, say narcotics case, my lord, so final report is final complaint is filed. So that is equivalent to the charge sheet. Now,
We are talking out here basically with regard to
Police investigation.
163 and 173.
yes, my lord, absolutely. Right, my lord. Oh, it starts from 170 when the opinion is formed, my lord, then the charge sheet will be filed. So just for a glimpse, can we go to the basic, my lord?
Nothing.
My basic submission will be that, my lord, under section 154, a case gets registered. The police acquires the jurisdiction to investigate the matter. Even if there is no FIR also, there can be investigation, there is no doubt of it, my lord. But normally it happens, but with the filing of the FIR under 154 case registration, my lord, investigation starts. Then thereafter, immediately 157 comes into play, my lord. Because the FIR is to be sent forthwith, that is more than urgent. Immediately thereafter, so there is no manipulation, change of name, these, that, my lord.
Yes, then.
My lord.
Yes.
Then the
Yeah, yeah.
investigation will start, and that investigation is defined under section 2H of the CRPC. What does investigation mean, my lord? Police comes out, collects information and all. In course of that, my lord, then if anything is seized, that is 102, my lord. From there, our case will start, my lord.
Section
102, my lord. Once police comes into the spot, he seizes certain things, my lord. That things are done by section 102, my lord. Under chapter 7D. my lord.
Yes.
Shall I read, my lord? Any police officer may seize any property which may be alleged or suspected to have been stolen, or which may be found under circumstances with certain suspicion of the commission of any offence. Such police officer, if subordinate to the officer in charge of a police station, shall forthwith report the seizure to that office. Your lordship got it, that's a report. The 451 language is production and non-production. 457 is non-production of the articles, physical form, and production of the articles in physical form. And in this 102, my lord, the report, that is the seizure list, is to be produced, get it endorsed from the magistrate, my lord, that yes, seizure has been made. Now, production and non-production will be coming by virtue of section 451 and 457. So here is a special provision. If your lordship will see, earlier it was up to provision 100, 1 and 2, my lord. Then feeling the difficulties, my lord, then the legislature was wise enough to amend it in 1978, my lord. And then by subsection 3 was introduced, my lord, inducted into the statute. But there, my lord, this Jimma things also comes written, my lord. Every police officer acting under subsection 1 shall forthwith report the seizure to the magistrate having jurisdiction, and where the property is seized is such that it cannot be conveniently transported to the court, or where there is difficulty in securing proper accommodation for the custody of such property, or where the continued retention of the property in police custody may not be considered necessary for the purpose of investigation, he may give custody thereof to any person or his executing a bond undertaking to produce the property before the court as and when required, and to give effect to the further orders of the court as to the disposal of the same. So the police himself can also give it if he comes to the conclusion, and if not, then what happens, my lord? That is the probably there will be the question we will be searching for, my lord. So police is also empowered.
No,
to-
you see out here,
My lord.
it says that the police may give custody
Yes.
thereof to any person.
Yes.
And,
That happened.
on is executing a bond undertaking to produce the property before the court as and when required, and to give effect with the further orders of the court as to the disposal. Now, disposal will come at which stage?
After a time,
Then, So we are now the issue prior to the trial,
Yes,
prior to
absolutely.
the inquiry.
Try, absolutely.
Now, if it's prior to the inquiry, whether 103 gives power to the trial court to give custody of the property to any person.
Yes, ma'am.
Well,
Yes. No, we have to we'll have to juxtapose everything and read it as a whole now, my lord.
no, we will do that,
Yes.
we'll do that. But let us see even singly, before we
Ah.
juxtapose.
Yes, yes.
Let us go.
One by one.
One by one. 102.3. A plain reading does not seem to indicate that that the court can give custody of a property except for disposal.
Now the,
And if disposal is after trial,
no, that's the end of the metaphor 52 or what.
so the investigation stage, it cannot give. That's what it appears to me.
No, prima facie, my lord.
Prima
But-
facie.
yes. But what I would, my lord, chip in here, my lord, that just visualize letters, my lord. An FIR is lodged, police comes to the place of occurrence, radius the place, takes everything, my lord. Practically difficulties we have faced within this intervening period, my lord, that in a PCA case, my lord, the police brought the whole file from the house of the accused person. They went to the police said, no, we cannot give you. You go to the court, bring the order, we'll give. That's practically what has happened, I'm saying. What the person was looking for, that in the thing, my lord, the Aadhaar card, the PAN card, the driving license, all original documents were there. So he wanted to have those documents. Police said, no, I cannot give you. I have seized it. You go to the court. Court says in view of the High Court judgment, we are not in a position to give it. So now what happens in that situation? Is the legislature intention was that no interim custody?
No, you see, now those are practical difficulties.
Yes, ma'am.
Now,
But what the law
you-
says?
the interpretation of the statute,
No,
you
that's,
see, unless there is ambiguity, we cannot interpret by way of gleaning or, or reading
Absolutely.
something into it that is.
we go by
that is
strictly
not-
by the statutes.
So, it doesn't mean that that the document that is to be released in custody has to be by way of the CRPC. It can be by way of 226.
That's what my lord.
There is a remedy available.
My
If
custody,
you, because now the thing is that if you say, because what you're trying to say right now is that this 103, if it doesn't have a provision for a court to give custody at the investigation stage, then we have got to read that into we have got to read that into this 1023. Basically read down the rules or whatever. No, but then when it is not capable of such an interpretation, when a statute is clear, then what to do? You have to go can you go beyond the statute?
no, never.
So we have to see. Now,
but-
if the Aadhaar card is not there, then you file an application under 226. There's no bar.
No, these are all alternative efficacious
That's
remedies. my
correct.
lord.
If it is not there, then I can understand the situation where there's no avenues at all. But here there is an avenue. It's only that at the time of investigation, can a court give custody?
My lord, so far Supreme Court's judicial pronouncements I have looked into, my lord, I could not find it directly, but impliedly it can be given. As Sundarbai has said, then I have got
No,
one.
there
which-
is one judgment, I think 1978,
Yes.
that though it has not gone deep into the issue.
No, but has dealt with it.
So
No,
you can,
Sundarbai went one step ahead and said that custody matters are to be decided within 15 days by the magistrate.
and it cannot be kept more than a month.
Yeah, absolutely. Absolutely. So
So,
then
ah.
thereafter came my lord.
So maybe, so in that way, you are agreeing to the submissions made by the state that yes, there is nothing in black and white allowing for a court to give custody during investigation.
To an extent,
to an extent.
to an extent, not
So,
completely.
so maybe your argument, maybe it should be in the line that even
we-
assuming that the provisions of the CRPC may not provide for allowing the court to give custody during investigation. However, since the Supreme Court has allowed it, we are bound by the Supreme Court judgments.
Yes,
In
otherwise
terms,
it will
in
be
terms
one
of,
way overruling the Supreme Court.
so maybe in that line,
Yeah,
maybe.
my lord, one respectful submission before I start with them. No, that's absolutely right, my lord. Because we are in a division bench, not to argue the case, my lord, but to argue the reference made, my lord.
Yes, correct.
So
Only
I have
that
to be
aspect.
careful, my lord, to submit, not taking any side, my lord.
Correct,
What the
correct.
law, as I understand and what my friends understand, and he also will be placing it so
Yes,
that
yes.
we arrive at a just and reasonable conclusion
Yes.
that this is the fair legal
Yes.
position, my lord. Nothing beyond that.
Correct,
Because
correct.
your lordship is not entering into our
Merits of the
property
case.
now.
We're not
Yes.
going into the merits of the
Absolutely.
case.
So we should not compromise with the legal aspects. my lord.
Yes, yes. Otherwise it'll.
Yeah, no, my
it'll
lord.
be a
We'll
problem.
not like to be a party, and neither would like your lordship to be a party to a
Correct.
illegal order, my lord.
We don't
Wrong
want, we
order.
don't want to be made a laughing stock.
Yeah, absolutely.
Everyone will say, what is this? Look at,
No, I think
look
with
at
your
what kind of
lordship,
order they have passed.
I think with your lordship acumen, we will have a very reasonable and legal judgment, my lord. I expect it from your lordship.
Hopefully.
Hopefully, my lord. So whichever way goes, but it should be proposition, my lord, because of the juxtaposition of the various laws, my lord. So I'll try one by one, my lord.
So I think we are quite clear
Yes, my lord.
with respect to 1023,
Yes,
that 1023 only the police can give custody
yes, yes.
during the investigation stage.
Absolutely, absolutely.
And that the words to give further orders of the court as to the disposal of the same.
No, no.
By using the word disposal, it applies to a stage subsequent to investigation. That means during inquiry also it can be done. Maybe
Now,
at
that's
trial
why,
or during trial.
my lord, we have to go to the basic three words: investigation, enquiry, trial.
Correct.
So investigation and enquiry is defined, trial is not defined under the code, my lord.
Correct.
Right, man? So the legal proposition as it comes out from the judicial pronouncement, trial is after framing of the charge when the date, the evidence date is fixed, my lord.
Correct.
Trial is said to have commenced. Prior to that, my lord, after filing of the charge sheet, till the filing of the framing of the charge is the enquiry stage. That is what Hardeep Singh, no, Hardeep Singh para 37 probably says, my lord. 27, more 37 goes. I think. Because enquiry is also not clearly written, my lord. So probably your lordship will have to look into the Maxwell dictionary or some
But with regard to what?
inquiry, my lord, so far.
Inquiry?
Because it
No,
is
no,
I.
I'll give you. I've done a
Yes,
bit.
yes, I understand. State GP Singh's statutes.
Inquiry in Hardeep Singh
Yes.
at para 27.
27.
It says the stage of inquiry commences insofar as
we
the
have-
court is concerned with the filing of the charge
Charge
sheet
sheet
and the
framing of charge.
consideration of the material collected by the prosecution that is mentioned in the charge sheet for the purpose of trying the accused. This has to be understood in terms of section 2G.
Correct.
So which defines inquiry
If
as
we
follows.
read 2G, my lord,
Yes.
I think it's not very easy way to say what the statute is saying, my lord. But in investigation, it is very easy to read and understand, my lord. That's my understanding, my lord. I may be wrong. I'll just read your lordship, my lord. Let us come to 2H, my lord. Investigation includes all proceeding under this code for the collection of evidence connected by a police officer or by any person other than the magistrate who is authorized by a magistrate in this behalf. So it is very clear, my lord. And for that, if your lordship wants to see, my lord, what is investigation, it's beautifully described in H. N. Rizban's case, AR 1955, my lord.
Just a minute. Investigation, the
What-
meaning of
investi-
investigation.
First time propounded by the Honorable Supreme Court in a very elaborate manner. two paragraph. H and Rizwan's case, AR 1955 SC, my lord, I'll give the. page.
AR 1955.
55.
SC?
H and
Page?
Rizwan. I'm giving my lord. I will give my lord. So there comes enquiry, my lord. It's not E, my lord. E and I, as I could find it out, my lord. E is in general term. Enquiry is for a specific term that you have been asked to do this, so you will inquired into this. So that's why it is I, my lord. One is E, my lord.
Yes.
We go to the railway station in the counter, that is an enquiry counter. So here it is in the code, it is I,
Yes.
inquiry, my lord. So that is what one aspect, my lord. So enquiry begins, my lord, from when and ends where, my lord. Now that is one issue, my lord, before your lordship. My lord. But
So in inquiry,
yes, enquiry.
Hardeep Singh has said, we just
No, no,
paid para 27.
Yeah,
clearly says,
absolutely. Yeah. But
with-
whether
It
that,
starts with the filing of the charge sheet. Inquiry starts with the filing of the charge sheet, not prior to that. So as soon as charge sheet is filed, then inquiry starts.
now we are bound by the Supreme Court.
Yes.
But with all respect, my lord, is it an absolute proposition? If I can show something different, my lord, probably may agree or may not agree. But for academic, I can place it, my lord.
But then aren't
Yeah, I
we
understand, my
bound
lord.
by the Supreme
Yeah,
Court?
yeah, absolutely. But let us,
Because you see, if you go, that is, no, what you're saying is very good, but then it might hurt you at the end for the simple reason that there is no clear-cut, black and white provision allowing for a court to give custody during investigation.
no, Supreme Court is not there.
But
Allahabad-
Supreme Court or judgments are there.
No,
So out here you are saying that you will not go by the Supreme Court decisions.
no, I'm
But
not
with
saying
respect
that.
to that, we want to go
No.
by, then you have to be very
No,
careful.
I'm
in your
not saying that,
submission.
my lord. Certain things may not be absolute proposition.
Okay,
Once we
Go
develop, my
ahead.
lord, it may come up in a different manner. If we
Okay,
look into
okay.
from a different prism, my lord.
And
Just I'm saying, my lord,
Hardeep Singh was by how many judges?
5 judges.
5 judges.
Constitutional bench
That's
referred matter. 319, while interpreting section 319 of the CRPC, that is additional person to be brought in as the accused in the case. my lord. So just reading, my lord, enquiry, my lord. What does enquiry means as per the section 2G? Means every enquiry other than trial conducted under this code by a magistrate. So here I would just like to chip in, my lord. Only one was in a negative form, it has been defined. Then what is enquiry? Anything that is not a trial is an enquiry, as I could read it, if your lordship will kindly see, my lord. If I'm wrong, kindly point
In
it out.
GP Singh.
No, my lord, from the definition itself,
Okay, yes.
enquiry means every enquiry. So
Other-
all enquiry,
Yes.
okay, comma, all enquiry other than a trial. So before evidence, my lord, it's all inquiry. Now I'll give an example, my lord. While your lordship sits and takes a bail matter, my lord, call for the case diary. Then what is your, just asking myself.
No, you're correct.
Yes. Then what is your lordship doing, under what provision your lordship is calling? What is that stage? Granting of bail and doing all these things. So if we lordship will again turn to page 172, section 172(3), we'll see the word enquiry. And this word enquiry, as I could find it out through my junior counsels, my lord, in the CRPC, my lord, in many a section that word has been used. At a page, junior executive. Well, I have made a chart to show that the word enquiry used in which part.
Let me just absorb what you're trying to say here. I find it quite interesting what you're trying to say here.
That
How-
I'm
how-
trying to-
Because if a court cannot interfere
Yes,
at the stage of investigation, then who are we to call for the CD also?
yes. That way, my lord. Then again, your lordship, if we go deep, my lord, very interestingly, your lordship will come. Inquest report. Inquest report, your lordship will find it starts from 174, my lord. I just read 172 then. So 172 diary of proceeding in
Just a
investigation.
minute,
Ah,
Mr.
sure.
Counsel. I had just made some note.
My lord.
I just want to see something. Anyway, yes, carry on.
Yeah. Then, my lord, just reading for your lordship's kind convenience, 172 says diary of proceeding in investigation. So every police officer making an investigation under this chapter shall day by day enter the proceeding in the investigation in a diary, stating forth the time at which the information reached him, at the time at which he began and closed his investigation, the place visited, and a statement of circumstance ascertaining through his investigation. 1A and B, the statement of witness recorded during the course under 161 shall be inserted in the case diary. The diary referred to in subsection 1 shall be in volume and duly pagined. Now, 2, my lord. Any criminal court may send for the police diary of a case under inquiry or trial. So these are the 2 words. Pre-trial and post-trial, we also say sometime. Trial, as we have said it at the outset, is, as your lordship is all aware, that recording of evidence starts, my lord, trial commences. Prior to that is pre-stage. Now, before pre-stage also, there is one stage that is inquiry. All that thing that is being done before filing of the charge sheet is inquiry by the courts. That is my responsibility. That inquiry, my lord. Otherwise, what is this inquiry then for? The court is to ascertain what is happening, what is not happening in the investigation. If somebody comes and complains that the police is not properly acting, the CJ may call for a report, my lord. That for the doctor's ill health of an accused. So that is during inquiry stage, my lord.
You see, now that will be going against the grain of the law laid down by the apex court.
That's why at the outset
Now,
I said.
that can be maybe argued before the apex court. But then how can we out here,
Once the law is, but that to five bench.
5 judges bench have already laid down the law?
I'm just pointing it out because.
Yes, because what you're trying to say is that there are 2 stages. So the investigation can also be a part of the inquiry.
Absolutely.
That is what you're saying.
Before the single bench, I made one strong submission that what the police does from the FIR till the charges in investigation stage, there is no doubt of it. H.N. Rizwan's case is squarely covering that aspect. And parallelly, what the court does during that investigation stage, according to me, is an inquiry till filing of the charge sheet. Whatever the court does, my lord, during that period, parallelly for the court, it will be inquiry, calling for the case diary, remand.
Anyway, but then that is a closed chapter now because of this Hardeep Singh
Hardeep,
incident.
of course. I have surprisingly find in that even in the inquest, just for academic and for my satisfaction, if your lordship will see that 176, the person dies of an unnatural death, my lord. Case is registered, inquest is conducted under 174, but in 176, there is a special provision for the inquest to be made by the magistrate, my lord. So that process is also called as inquiry, my lord. I'll read, my lord. 176, inquiry by magistrate into cause of death. When the case is of the nature referred to in clause 1 or clause 2 of subsection 3 of section 174, the nearest magistrate empowered to hold inquest shall in any manner case mentioned in subsection 1 of section 174, any magistrate so empowered may hold an inquiry into the cause of death either instead or in addition to the investigation held by the police. So parallelly, the magistrate who goes for the inquest, my lord, is making an inquiry apart from the investigation being done by the police. And one last submission regarding that, my lord, I'll skip, my lord. If your lordship will just
No,
see-
but then,
No, just one line,
yes, yes.
because I prepared on that line,
Okay,
I'll just
okay,
ventilate my
Okay, okay.
submission, my lord. The jurisdiction of criminal courts in inquiry and trials. So this chapter is chapter 13, my lord.
Yes.
Ordinary place of inquiry or trial. Every offence shall ordinarily be inquired into and tried by a court within whose local jurisdiction it was committed. So inquiry never extinguishes, my lord. During investigation, if this proposition goes, my lord, lordship takes it, my lord, then the court will be functionless, my lord. All this time, my lord, how will all these happenings in the criminal court will happen, my lord? So it is only when the police will file the charge sheet, my lord, then only the court can invoke its power in all aspects. But that is not the mandate of the CRPC, my lord, I think. That's why I respectfully submitted before the single bench, and I'll like to retreat it, but if the lordship wants to escape, but I will not go deep into the matter, I'll cut short my argument. That whatever the police does is investigation, and during that investigation, whatever proceeding is brought before the court, criminal proceeding, my lord, is an inquiry being made by the court, my lord, to
No,
ascertain.
but then how, when the Supreme Court has given
No, that's.
has given their definition
Wise
of
full-
inquiry in terms of the CRPC, section 2G. How can we give a different interpretation than what has been provided by the
I think
Constitution
in
bench?
that case, not interpreted 2G, but has said about inquiry, my lord.
Yes.
2G was not interpreted at
No,
large,
but
my lord.
then that.
But has
no,
said, yes.
But has said that, because
Yes, yes,
the
yes.
word used is, this has to be understood in terms of section 2G CRPC.
Yeah, that is what only said, my lord. But why it is being said, no specific reasons has been given, with all respect.
Who are we to question?
But just making an endeavor to
No,
understand
it's
the law
it's
in a
okay, but
better
then the
proportion.
problem is that supposing we follow.
No, no, we are
your
bound to follow it, my
submission,
lord.
supposing we follow a submission and we agree with your point of view. At the end of the day, we still have to
To follow that hardship.
follow the decision of the apex court.
Absolutely, fine, man. That's
So,
true.
so
No, sure, my lord. I
that
understand
is
that,
the problem.
that worry of your lordship, my lord. No issue, my lord. Now, let us come directly to the point. So, my lord, I have scanned through my juniors also. We could not directly find any judgment pertaining to Supreme Court judgment, judicial pronouncement, whether during investigation stage, that chapter 32 applies or not. That is
No,
starting.
I think, yeah.
But I have got certain courts,
No,
high
there
court
is, there is
judgment.
one judgment. I think 1978.
70 Ram Prakash Sharma versus Haryana.
Just
78 2 SCC 491.
yes,
Ram
please,
Prakash
please
Sharma.
read
Then
the
Ambika Roy is there and
three
one
section, this para,
Vasava Com D Patil.
para 3, 4 and 6.
Yes, I'll read to your lordship.
Para 3, 4 and 6. No, I think I've got it.
Your lordship.
Compilation page 52.
52.
But I'll prefer to read from para 2, my lord, because
Yes,
it
okay.
starts with that. Chapter 34 of the CRPC deals with disposal of property. There is a trichotomy in the sense that where property has been seized by police but not produced before the court, the power to dispose of it is covered under 457. Where property has been seized and or otherwise produced before the court, the manner to dispose of such property is governed by section 451. If the question of disposal arises after the inquiry or trial in any criminal court is concluded, the disposal of the property involved in the case is governed by section 452. We need not go elaborately into the implication of each provision since we are not called upon to do so in the present case. Section 457 covers the facts of the present case. The police have recovered a considerable sum of money from the appellant, and the money is stated to be seized in connection with an offence registered against an accused person, namely Bansi Lal. Whether the appellant himself will be a witness or an accused is not possible to state at the present moment according to the counsel for the state. Be it as it may be, the situation is clearly covered by section 457 CRPC. However, the fact that the court has power to dispose of property seized by the police but not yet produced before the court does not mean that the special judge must always release such property to the person from whom the property has been recovered, especially when the stage of the case is in suspicion. The investigation is not over and charge sheet has not been laid. The court has to be circumspect in such a situation before releasing the property. While we reverse the decision of the courts below that the special judge has no power to release the said property, we should not be taken to mean that whatever the claimant asks for the property back, he should be given back the said property. That has to be decided its own merit in each case, and the discretion of the court has to be exercised after due consideration of the interest of justice, including the prospective necessity of production of these seized articles at the time of the trial. If the release of the property seized will in any manner affect or prejudice the course of justice, at that time, the trial will be a wise discretion to reject the claim for the return. In the present case, counsel for the state is unable to state whether the future prosecution may have to rely upon the currency note in special seized from the appellant. It is quite on record that they may be so required, specially having regard to the circumstance that the monies are stated by the prosecution to have been buried, although the appellant in discourse stoutly denied this allegation. All that we needed to do at the moment is to uphold the power of the court to release the property and direct the special judge to hold an investigation into the necessity of the notes seized to be retained with the police or in the court for future use at the time of inquiry or trial. If he is of the opinion that the notes are so required, the property shall not be released. If on the other hand, the notes are not needed in any manner in the later stage, the inquiry or trial, it will be proper for the court to release the property on the appellant furnishing adequate bond. In reaching the conclusion, we have taken note of the decision of this court in Vasava that I am relying on. My Vasava Com Dayamunda Patil was state of Mysore. Of course, the appellant should not indefinitely keep property in his custody or need the court keep the property seized and produced before it unduly on. But this does not whittle down the need of the court to be vigilant when an application is made to return the property seized by the police as to the necessity of such property being recovered in the future course of the trial. Having regard to this circumstance, the court will pass appropriate orders under 457 regarding the disposal of the property seized by the police in this case. The special judge will dispose of the matter expeditiously since considerable time has elapsed. The appeal is disposed of accordingly. So by virtue of this judgment, it is explicit, my lord, that 457 can be invoked, my lord, while giving the custody. And I have got, my lord, no direct decision from
But
the,
it has not specifically gone
Yes.
deep into
Deep-
the
deep
issue, but it
into
is just stated.
yes, because the need of the hours wants that, my lord, because natural justice is also one proposition, my lord. But I have got Supreme Allahabad High Court Division Bench and one from Himachal Pradesh, my lord, single bench, which directly says, my lord, that during investigation also it can be given. And
And
also
then
say,
we'll look into this 19, this
yes, I have got
74
it, I
4
have brought
also.
it, my lord.
Okay.
That was in the stage of trial, it was granted.
Stage of trial.
77.
Okay, but this case that the learned senior counsel has just read out. This is at the
This case,
investigation
my lord,
stage.
in my humble submission, it will be sub silence, my lord. It has not specifically held that during investigation 457 is
No,
applicable.
it has stated. You see
Clearly
it in
stated.
para
On facts,
4.
it is stated.
It
Para
is
five-
said for use, for future use at the time of inquiry or trial also.
On facts.
So
has
it
been
is
said
very
so.
clear
Mhm.
that it has been given it has been, the custody has been allowed to be released prior to the inquiry. It has been, it's very
On
clear in
facts,
para
my
4.
lord, on facts,
On
prior
facts.
to the inquiry, custody was given, but it's not a ratio in RAM, my lord. That in all cases, 457, the investigation word is already inserted in 457, my lord. Because my lord will also see, my lord has seen para 5, they have referred to that 77-4. But my lord, I think my lord is rising for some time.
No. So it's, there are
There are-
points in your favor
There-
and there are
there-
judgments in his favor.
Exactly. Which will prevail, that's the.
The provision.
The
is
one
in-
which is
the-
favorable to
The
the
provision is in
society
your
at large will
favor,
prevail, my lord.
but the final interpreter of the law
Yes.
is the Supreme Court.
Absolutely.
True, my lord, but I don't think, my lord, this is a judgment based on.
Can the division bench say that the Supreme Court
The division bench can
judgment
say-
is not a judgment in rem? Would it be proper for us to say that?
But if a judgment is passed on a specific fact.
No, no,
it
well,
is-
my lord,
it is-
certain things are also impliedly said. It is not that all the time we
There
have
is
to
a-
be
there
black
is-
and
there is-
white.
there is an implication in the order.
Implications, my lord.
I will give you
By
time
virtue
to,
of that.
this,
Law of
this query has
implications.
been, has come to our mind.
Law of implication.
But my lord has seen in the
Law of
judgment, there is
implication.
no deliberation on this aspect, my lord. That
No,
is
you
what
see,
we
you
are
see,
doing.
why? Because it has said, we need not go elaborately into the implications of each provision,
Yes.
since we
That
are
is
not
it.
called upon to do so in the
So they
present
have
case.
not compared, Honorable Supreme Court has not compared 451, 452 and 457, or in isolation,
But
457
they
has
are
been
not
dealt with.
saying that, they are
But,
not
but
saying
that takes care
that
of
they
it.
will take a different view. They are saying that basically what it implies
Well, what I'm
is
saying,
that
that
going
was-
by when the provisions are already there,
well,
this is the order that we
the
pass.
present issue, my lord, was not an issue before Honorable Apex Court in that case, my lord.
Anyway, we'll carry on, just 1 minute.
Man, sure, we'll be back, my lord.
They've not cited you. Senior Honorable is on legs.
This is on legs.
I'm sorry, madam. Just hold on. Okay. itu judgment of Rashid.
Yes.
My lord. I'm a bit late. Now coming directly to addressing to those points, Mala, what I was saying before parting, Mala, that we don't have direct judgments from the Honorable Supreme Court, Mala, but there are judgments from Honorable Allahabad High Court Division Bench and single bench, wherein it clearly says, Mala, clearly says, and that was the issue before the court, Mala. Court 5, but also High Court.
Yes.
Malak, this is a division bench matter, Malak, and the same thing happened in what we are doing today, Malak. Probably the same thing happened in Allahabad High Court way back in 1978, Malak.
Yes.
Because by a 1976 Criminal Law Journal, Allahabad, it was overruled by this division bench regarding this point, that order regarding seized property, magistrate can make order during investigation also. He need not wait until trial or inquiry is concluded. Words is not produced before the court during inquiry or trial, meaning. So in great details, it has been looked into, my lord. These are the three connected cases. Criminal Revision 1253 of 77 is by Ajay Singh against an order of the learned resistance Sessions Agra dated 24, setting aside the order of the magistrate dated 2nd August, releasing the track number UPU miss is an application by Ram Naresh Singh, section 482 criminal procedure is an application by Abdul Razak under such. The facts concerning Criminal Revision 123 are that the truck number Iman was seized by Hari Parvat police station during investigation of a murder case. Ajay Singh applicant moved an application for release of the truck. This application was allowed by the magistrate and the truck was released in favor of the applicant on his furnishing two surety, each of an amount of rupees 10,000. With a personal bond in the like amount on the Thilal opposite party filed a criminal revision in the court of the Sessions of Agra. The revision was heard and decided by the learned additional sessions. The revision was allowed and the order of the learned minister releasing the truck in favor of the applicant Ajay Singh was set aside. Ajay Singh therefore filed a revision in this court. The fact relating to the criminal miscase number such or tractor number such belonging to Ram Naresh Singh. On the night between 27 and 28, the tractor was seized by the police at Kachawai police station. As some dacoits who have committed dacoity on the same night at 11 p.m. in the house of Lalta Prasad in village Rampur police station, Kachwa, were traveling by it. An application was moved for release of the tractor by Ram Naresh Singh before this magistrate on 4th June. It was dismissed on 9 June 77. It is against this order, the magistrate dated demand that the application on the 482 has been moved before this court. And these are the facts, my lord. Let's come to 5 mile. The impure order in all these three cases are based on the authority reported in Nannu Mal versus Sher Muhammad Khan. In all that case, the police seized the truck along with its trolley from the possession of the applicant Nannu Lal in connection with a case under 147, 142, 341 IPC. Sher Muhammad Khan made an application for release of the truck and trolley in his favor. The magistrate allowed the applicant to release the truck and the trolley in favor of Sher Muhammad Khan, which has been heard by Nannu Mal thereupon made an application under the provision of section 482, which was heard by Honorable Kaju, who was of the view. A plain reading of section 451 clearly shows that it is applicable only where the property seized is not produced before a criminal court during an inquiry or trial. A magistrate under this section can make an order regarding the seized property only after the inquiry or trial is concluded and the seized property is in fact not produced in inquiry trial. He cannot make an order regarding the seized property under this section during investigation of the case. Under section 523(1) CRPC, it was open to a magistrate to pass order regarding the disposal of the seized property during the investigation of the case. There is, however, no provision in the CRPC similarly to 523 CRPC. A magistrate has therefore no jurisdiction to pass order regarding the disposal of seized property during investigation of the case under the Criminal Procedure Code 1973. There appears to be a lacuna in the Criminal Procedure Code 1973 in this regard. It is, however, well settled that the courts cannot correct mistakes of the legislature and fill up the lacuna in statute. This has obviously to be done by the legislature itself. The order of the magistrate and of the additional district and session judge were accordingly set aside. At the time of the admission of the Miss Case 1169 of 1977, Honorable H.N. Kapoor doubted the correctness and decision of the case in Nanumal versus Sher Muhammad Khan, 1976 Criminal Law 173, as he was of the view that the matter required reconsideration by a larger bench. Accordingly, he made a reference in this case. Similarly, a reference was also made in Criminal Division 1253 of 1977 and Miss Case number 3865. The question for determination in these three cases is therefore regarding the import of the provision of 457 CRPC, and it is to be seen whether the decision reported in Nannu is a correct statement of law or not. Same thing we are looking for, my love. We are in search of this same thing, my love. Section 457, which your lordship was telling from the very outset, my lord, with all appreciation, I will say, your lordship only said 457 is the probably will be the right provision. Here also the High Court said this way. Section 457 1 CRPC provides as follows. Whenever the seizure of property, so this is the court, my lord.
170.
I read 8, para 8. Section 457 is one of the provision of chapter 35 of the CRPC entitled as disposal of property. There are two other sections, 451 and 452, on the same subject, which has some bearing on the interpretation of 457. Section 451 empowers the court to order for interim custody or disposal of the property produced before it during any inquiry or trial. Section 452 gives jurisdiction to a criminal court to order for disposal of property produced before it during inquiry or trial, or trial the conclusion of the inquiry or trial. Section 467, on the other hand, deals with property seized by any police officer but not produced before a court during an inquiry or trial. It is more or less a residuary provision dealing with property not covered by 451 and 452 and is applicable when first the property has been seized by the police. Such seizure is reported to a magistrate under the provision of the CRPC. Third, the property so seized is not produced before a criminal court during an inquiry or trial. The ambit of the last two conditions depends upon the meaning of the word is not produced before a criminal court during an inquiry or trial. The cardinal principle of interoperation of the statute is the words should be read in their ordinary, natural, and grammatical meaning unless a reading leads to absurdity. If the words are susceptible to another meaning, the court may adopt the same. In the expression such property is not produced before a criminal court during inquiry or trial, the legislature has used present indefinite tense in passive voice. As such, it is not permissible to interpret them to mean may not be produced in the court in inquiry or trial at any time or will not be produced in inquiry or trial, so that the magistrate has to wait until an inquiry or trial is held by a criminal court and the property is actually not produced in the court. The word is not produced, etc., have reference to the point of time when the magistrate to whom the seizure has been reported is called upon to make an order for disposal of such property. At the relevant time when he has to make an order for disposal of property, the magistrate has to ascertain if the property is produced or not in a criminal court during inquiry or trial. If it is produced, he will have no jurisdiction to deal with it. In case it is not produced before a criminal court during an inquiry or trial, he will make an order for disposal in the prescribed manner. A magistrate may have to exercise jurisdiction under section 457 in different situations and circumstances. A person whose property has been seized may apply to the magistrate for his release while the investigation is still in progress, and such before the commencement of inquiry or trial and before an occasion produce the seized property before a criminal court arrives. Such a situation also arose in the case reported in Ambika Roy versus State of Bengal, 1974 Criminal Journal 302 Calcutta. A division bench of the Calcutta High Court held at page 1004 and 1005. On consideration of the relevant provision of the code and in the light of the principle of the interpretation of the statute, it is abundantly clear that 457 CRPC in the context of earlier provision laid down in chapter 34 and should not be constituted benefit of such context. The word such property is not produced before a criminal court during an inquiry or trial merely refer to the stage of investigation and not the stage of inquiry or trial. If the property is produced in the criminal court during an inquiry or trial, section 451 of the new code would apply and not 457. The word relied upon by the Chief Metropolitan Magistrate Calcutta therefore do not constitute a bar but a condition precedent, not a disqualification but a qualification, and not an exception but an essential ingredient forming the mainspring of such application. The learned Chief Metropolitan Magistrate Calcutta has misconstrued the said word to find ultimately that in this case there is a non-production, but the non-production is not during trial but prior to trial. The learned magistrate proceeded on the purported footing that the inclusion of the aforesaid words in the statutes required in the first place the non-production of such property as opposed to production, and secondly, that the factum of such non-production must be during an inquiry or trial. It is abundantly clear, however, that ultimately there is no cloud and the legislature in its wisdom merely used the said words in order to differentiate the various stages, that is the stage of inquiry or trial, completion of the trial, and of the investigation, etc. In this particular case, it appears from the record that the condition precedent enjoined in section 457 of the criminal procedure have been fulfilled, namely that the factum of seizure has been reported to the magistrate under the provision of the code and the properties produced has not been produced an inquiry or trial, but at the stage of investigation. Similarly, are the facts of the case reported in MS Jaggi versus Subhash Chandra Mohapatra, Odisha, relying upon the authority reported in Ambika's case. It was held that the expression and such property is not produced before criminal court during an inquiry and trial refers merely stage of investigation and not the stage of inquiry or trial. So this is parallelly going on, madam. Again, there may be a case where the police, after completion of the investigation, submit a final report under 169, and aggrieved party might approach the magistrate, although the stage is prior to the commencement of inquiry and trial. Again, an application may be made for release of property seized but not produced in court after conclusion of inquiry trial. We find nothing in the language of section 457 to restrict its application only to the last category of cases and take away the jurisdiction of the magistrate until trial or inquiry is held that the property is actually not produced in the court during investigation case. The provision might be availed of in other situations also. In our view, therefore, the statement of law made in Nano Mal's case is not accurate, being too narrow. In criminal revision is allowed, the order of the learned third edition session judge Agra dated remand set aside and the order of magistrate is restored, that is releasing the property in custody. Application in criminal case is allowed and the order to the magistrate dated 9 is set aside. The property has already been released by this court. The magistrate may, however, pass such an order as may be necessary in the circumstances of the case regarding the disposal. Application number such is allowed and the order of the metropolitan magistrate session judge has set aside. The property has already been released by this court. However, the metropolitan magistrate Kanpur may pass such order as disposal and security as is warranted by the circumstances of the case. So by virtue of this division bench judgment, my lord, this is explicit. My lord, that during investigation also it can be done. And in a much better manner, Himachal High Court, single bench of course, has more elaborately dealt with that thing, my lord. That is inquiry or trial, meaning matter in the stage of not one inquiry and trial. Magistrate power to disposal, matter is stage of police investigation, disposal can be ordered by them. It's regarding the PCA case, my lord. Certain case amount was found, my lord.
Matter going on in another court, my lord, will be back within 5 minutes.
I'll take 10-15 minutes. If your lordship permits.
Come on.
My lord, this case, Himachal Pradesh case, my lord, emanates also by relying upon this Allahabad High Court judgment. Your lordship will find it in para 3, my lord.
Para 3.
Yes, my lord.
Yes.
Yeah, my lord, I'll go by para 2, my lord, for a better understanding of the proposition. It is the first contention raised by the petitioner, which is more important because it touches the question of jurisdiction of the learned special judge to act under 457 CRPC. On this point, the contention raised on behalf of the petitioner was that 457 can be invoked only when it is found that the property seized by the police is not produced during inquiry or trial. It is pointed out that in this case, the stage of inquiry and trial has not yet reached because the police has not submitted any charge sheet and the matter is still pending for investigation before the police. It was therefore contended that the learned special judge has no jurisdiction to pass any order under 457 of the code. In support of the above contention, the learned advocate for the petitioner put reliance upon the decision of the Allahabad High Court in Nano versus Sher Muhammad Khan reported in 76 Criminal Journal. Another, that 76 is that overruled judgment, my lord.
Yes.
And another decision given by Andhra Pradesh High Court in Balaji versus State of Andhra Pradesh reported in such. In both these cases, the provision of 457 code has been interpreted and it is held that 457 would apply only when the seized property is not produced before the court during the course of inquiry or trial, and order thereunder can be made only after the trial is concluded. Following are the relevant observation made by the Allahabad High Court. My lord, this is an overruled judgment, so I think we can skip, my lord.
No, you please read anyway. How does it?
Sure. A plain reading of section 457(1) 1973 clearly showed that it is applicable only when the property seized is not produced before the criminal court during inquiry or trial. A magistrate under this section can make an order regarding the seized property only after the inquiry or trial is concluded and the seized property is in fact not produced in inquiry or trial. He cannot make an order regarding the seized property under this section during the investigation of the case. Under section 523(1) CRPC Old Code, it was open to the magistrate to pass order regarding the disposal of the seized property during the investigation of the case. There is, however, no provision in the CRPC 1973 similar to section 523. A magistrate has therefore no jurisdiction to pass order regarding the disposal of the seized property during the investigation of the case under the CRPC 73. There appears to be a lacuna in the CRPC. In this regard, it is, however, well settled that the courts cannot correct mistake of legislature and fill in the lacuna in the statute. This has obviously to be done by the legislature itself. The Andhra Pradesh High Court has considered all the relevant provisions with regard to the production and disposal of the property, and comparing them with the provision of the old code has come practically of the same conclusion, but has made some more observations going to show that unlike the provision contained in 523 of the old code, under the provision of section 450 of the new code, there is no obligation on the police to make report to the magistrate with regard to the seized article. However, both the referred decisions are based on the reasoning that the stage of inquiry and trial cannot state to have reached when the matter is under investigation by the police. And if that be so, it cannot be said that the property was not produced during the course of inquiry or trial, and therefore section 457 of the code has no application in such a case.
No, I don't get this part. What does it mean out here?
Para 5, my lord.
Yes.
However, both the above referred decision, that is the Allahabad and Andhra Pradesh,
Okay.
based on the reasoning, those two judgments reasoning, the stage of inquiry or trial cannot be said to have reached when the matter is under investigation by the police. That is correctly said, my lord. When the investigation is going on, it cannot be said that it has reached the stage of inquiry and trial. It cannot be said that the property was not produced during the course of inquiry and trial, and therefore 457 has no application in such a case. So the Allahabad High Court earlier 76 prior to the overruling by the division bench, that came to be overturned in 1978, my lord. 76 is being dealt with it, the overruled one, my lord. So at that time, it was the law was that that's under
Unless it is produced.
Yeah, yes, absolutely. Correct.
But now out here is no requirement of production.
Production. As against this, the High Court of Calcutta and Odisha have taken a different view. A division bench of Calcutta, that is Ambika Roy's case, my lord, 74, that the word such property is not produced before a criminal court during an inquiry or trial merely refers to a stage of investigation, not the stage of inquiry or trial. During the course of their judgment, the learned trial court has not given any reasoning as to why they are of opinion that the stage of inquiry or trial refer to the stage of investigation by police. The High Court of Odisha followed the above referred decision of the Calcutta High Court in MS Jaggi versus Subhash Chandra Mahapatra, reported in 77 Criminal Journal 1902. In view of the conflict decision between the above referred High Court, the points which arises to be determined is whether the expression inquiry or trial which is used in 457 means the stage of investigation. That is what we are looking for, madam. Stage of investigation by the police as held by the Calcutta and Odisha High Court, or whether it means the stage of inquiry or trial before the court in the main case. While considering this question, it would not be out of place to state shortly the scheme as regard the disposal of the property as envisaged in chapter 34 of the CRPC. Section 451, which is the first section of this chapter, contemplates the order of custody and disposal of property pending the trial, and says that when any property is produced before any criminal court during an inquiry or trial, the court may make such order as it thinks fit and proper custody of such property pending the conclusion of the trial. Thus, section 451 contemplates order with regard to the property which is produced during the trial, inquiry or trial. Section 452 contemplates disposal of property at the conclusion of the trial and says that when an inquiry and trial of any criminal court has concluded, the court may make such order as it thinks fit for disposal. The section 452 refers to a stage when the trial is concluded. For the decision of this point, we are not concerned with 453 to 456. We therefore come to section 457, subsection 1 thereof in the following terms. Whenever the seizure of property by any police officer is reported to a magistrate under the provision of this code, and such property is not produced before the criminal court during an inquiry or trial, the magistrate may make such order as he thinks fit respecting the disposal of such property or the delivery of such property to the person entitled to the possession thereof, if such person cannot be ascertained, respecting the custody and production of such property. A plain reading of this section showed that it contemplates a contingency wherein even during course of inquiry or trial, the matter in the court, the seized property is not produced before the court. If the same is produced before the court during the course of inquiry trial, then section 451 would apply. But if it is not produced, 457 would apply. So this is during investigation. It is evident from the reading of section 451, 452, 457, the words inquiry or trial are used in the same sense in all the three sections. The word trial is not given any statutory definition, but the word inquiry is defined by section 2G of the code. Inquiry means every inquiry other than a trial conducted under the code by a magistrate court. In ordinary circumstances, and unless it is otherwise found in the context, the rule of interpretation is that if a particular word is statutorily defined in the statute, then the definition should prevail. Therefore, when section 451, 452, and 457 speaks of an inquiry, this speaks of the inquiry which is defined in 2G of the code. There is nothing in the context in which the expression is used, section 451, 452, and 457, to show that it should be given any meaning which is other than the statutory meaning given in section 2 of the code. Under the circumstances, I find that it is difficult to accept the view taken by the Calcutta and Odisha High Court, and the expression inquiry or trial connotes the stage of investigation by police. rightly probably said, my lord. If this is so, it is obviously that before the stage of inquiry or trial in the court arrived, jurisdiction under section 457 cannot be exercised by the magistrate. To this extent, I find myself in agreement with the view taken by the Andhra Pradesh and Allahabad High Courts. I however find there is no justification for taking the view that the magistrate or the court for that matter is powerless to pass any order with regard to the property seized by the police before the stage of inquiry or trial has reached. I find the provisions of section 459 of the code have not been brought to the notice of the Allahabad or Andhra Pradesh High Court or the Calcutta or Odisha High Court. The provision of section 459 are as under. Power to sell perishable property. If the person entitled to the possession of such property is unknown or absent, and the property is subject to speedy and natural decay, or if the magistrate to whom the seizure is reported is of the opinion that its sale would be for the benefit of the order, or that the value of such property is less than 10 rupees, the magistrate may at any stage, at any time, directed it to be sold, and the provision of section 457 of 458 shall as nearly as may be practical apply to the net proceed of such sale. The main para now starts, my lord. The plain reading of this section shows that the concerned magistrate can exercise the power which the court has under section 457 and 458. The court under any of the three circumstances, namely if the person entitled to the possession of such property, that is the seized property, is unknown or absent, and the property is subject to speedy and natural decay. Number two, if the magistrate to whom the seizure is reported is of the opinion that the sale would be for the benefit of the owner, that the value of the property is less than rupees 10, in either of these circumstances, the magistrate can utilize the powers vested to him under section 457 and 458. The second circumstance, namely that the sale should be for the benefit of the owner, does not depend upon the report of the seizure by the police, because the report can be given to the magistrate by any person under 459. Therefore, even if the accused or any other person for that matter can draw the attention of the magistrate that the property is seized by the police and that its sales would be for the benefits of the owner, when it is done, it will be open to the magistrate to take action under 457 and 458, applying the provision as nearly as may be practical. Under the circumstance, I am of the opinion that even if in a given case, the stage of inquiry or trial has not reached, the matter is pending investigation by the police, the magistrate can be moved under section 459 of the code. My 459 is from the old code, my lord. So far as this case is concerned, I find that in this application, which the Deputy Superintendent of Police CID has moved, he has referred to 459, but it appears that the learned special judge has confined his attention only to 457 and has passed the order accordingly. He could have passed order after the requirement of 459 and found satisfied. Since he has not applied his mind to the requirement of 459, the only course left open is to set aside the order, which is sought to be revised, and to send the matter back to learned special judge with a direction to pass suitable order under 459 after giving due necessary opportunity to both the parties to be heard. The rule is made absolute, thus the order on such terms. So what it emerges, my lord, that 457 is applicable also during the investigation
Where
stage.
does it say it says 459?
My 459, actually, that was decided in the context of that factual aspect of that case, my lord. No, here 73 code is being referred. Here it was power to sell perishable property in under the new code, my lord.
So this is with regard to 459.
459, no. 457, the order was passed. The judge said that no.
It can be done under 459.
Yes.
So for that, so the conditions required under 459 would have to be
Fulfilled.
fulfilled. So that way, 457 is not applicable as per this.
No, same thing, my lord. 459 is only for perishable goods.
For perishable goods.
With perishable.
Yes.
And when the person is unknown, my lord.
Correct.
But facts remain that during investigation. So lastly, another.
But so 459 is with regard to certain goods only,
Oh, yes.
not with all goods.
Not in all goods. That's why, but at the very outset, I pointed it out, my lord. Actually, if we can, to understand this legal proposition in a better manner, my lord, what actually happens practically in the field, as a trial court lawyer, I'd like to just point it out within 2 minutes, my lord. So when an FIR is lodged, police goes out, investigates, makes a seizure, takes certain things into their custody, my lord. They bring all their things, whatever will be required, they will scrutinize it. And if it is a case property, say a weapon or arms, so all these are sometimes taken into custody, my lord. Gold jewelries, maybe stolen property. Now the owner comes forward. Say, my lord. The owner comes forward and say, this is my golden property. So what purpose will we serve when it is retained till the trial gets? So if we go by the scheme, strict to the interpretation, my lord, as my learned friend is trying to say, then all these gold ornaments will be stored in the police malkhana. That is called this MR, police malkhana register. It will be entered and it will be kept. Then when it is submitted to the court, it will be in the court malkhana register. Situation arose during a particular period of time, my lord. Lots of things were stolen from the malkhanas. Then the Honorable Supreme Court came up with a proposition, no. Without taking the risk, it will be a better proposition that we should give in Jimma to the people, my lord. That way the Jimma concept also developed, my lord. Then again, another concept developed in somewhere around 2010 or something like that, my lord, that regarding stolen vehicles. Lots of vehicles were stolen, my lord. Then police used to be successful in recovering certain things and kept in the police station, and it get damaged and the rightful owner doesn't get it, my lord. So that way also, if your lordship will look into the General Insurance Council versus State of Andhra Pradesh, my lord. So was of also the view, my lord, that yes, custody is the ultimate thing which should be given pending trial, my lord. Your lordship will kindly looked into 2010 6 SCC 768. I'm sorry, my lord, today. This one again. 2010 6 SCC 768. I'm sorry, my lord, I'm handicapped today. I'll just share one copy right now. I'm sorry. Huh? No, Ambala's reference is there. That is the backdrop. Actually, lots of vehicles were being stolen once upon a time. So, what recovery puri thake. Insurance Council came up with the idea that now DD go. তোমার কাছে জজমেন্ট আছে এটা কপি লাগিয়েছিল আমার কাছে এটা শর্ট This is one judgment which is also impliedly saying, my lord, that during investigation, my lord, whether produce or not produce, custody can be given, my lord.
Where, which para?
Yes, my, we'll read, my lord. Let's read together, my lord.
No, which para?
My lord, it starts from para 5, my lord.
You are reading the entire judgment.
No, my lord, I'll just, this is the, I'm handicapped, one copy is not with me. Kodibo parimoni photos. Just one moment, my lord.
This photo set is also very bad copy.
Oh, no, here we have a better one, my lord. I'm sorry, my lord. Duta Kodi.
You are giving us all the bad copies.
Sorry, Malina. Actually, I had one, Malina. One of my landed junior colleague gave me. I'm so sorry, Malina.
So you're not bothered about.
No, Malina, not that way, Malina. Actually, last night I prepared it, Malina. There's another case from that copy comes, Malina. Can I proceed, Malina? Malina, in a Guwahati High Court case, Malina, Muhammad Razibul Islam, Malina, also. In this case, also, Malina, we find that the Honorable High Court of our High Court, my lord. Same thing, let me copy to my note. Relying upon Sundarbai and one Kumar trace, these betel nuts were given in Jimma, my lord. That last judgment, I would like to say, my lord, that there also the section 451 and 457 interpretation is there, relying upon the Sundarlal Ambala's case, my lord, Ambala Desai's case, my lord. That squarely covers the whole issue, my lord. So otherwise, my lord, if we go by this Sundarbai, my lord, it has been clearly stated, my lord, that 451 can be exercised, my lord. And also relying that Basava Common Dayabhai Patil's case, my lord.
Yeah.
If we, for the time being, looked into the proposition propounded in Sundarbai Ambala Desai case, there is no doubt left, my lord, that during investigation, powers under section 451 and 457 cannot be applied. Though this Ambala's case was decided purely on giving custody under section 451, my lord. Because there is a clear direction, my lord. If your lordship will see.
Where?
My lord, in the second page, my lord, in the head note. For this purpose, the court may follow the procedure in the middle, my lord, of recording such evidence as it thinks necessary as to provide under 451. The bond and surety should be taken so as to prevent the evidence being implied, lost, altered, or destroyed. The court should see that the photograph of such article are attested or countersigned by the complainant, accused, as well as by the person to whom the custody are handed over. Still, however, it would be the function of the court under section 451 to impose any other appropriate condition.
Where are you reading?
I'm in the second page, my lord. So,
Which para? Which para?
yeah, my lord. I'll take it to your lordship to the main judgment, my lord. My lord, this is Sundarlal, my lord.
Actually, Sundaral Ambalal is the judgment. Okay, which judgment are you referring to?
Address 2002 10 SCC 283, my lord.
Yeah. Which paragraph?
Yes, my lord. Para 21 is there. The last finding, my lord.
Yeah.
See, however, these provisions are to be exercised by the magistrate concerned. We hope and trust the magistrate concerned would take immediate action for seeing that powers under 451 are properly and promptly exercised and articles are not kept for long time at the police station, in any case for not more than 15 days to 1 month. The object can also be achieved if there is proper supervision by the registry of the High Court concerned in seeing that the rules framed by the High Court with regard to such article are implemented properly. So wide power has been given by this judgment, my lord.
But They have not gone into the question of whether 451 can.
Yes, that's what I said, my lord. It has
They
been-
have gone straight into the judgment of Basaya Com.
Yes.
So it was on that aspect only.
No, though not interpreted, but has said, my lord, that section 451 is the power. Para 10, your lordship will see, to avoid such a situation, in our view, powers under section 451 CRPC should be exercised promptly and at the earliest. So if we go into the totality of this the judgment, my lord, the Malkhanas, it should not be written. It should be immediately released, preferably within 15 days and 30 days. Now, suppose a vehicle, some persons are traveling who may be terrorists, the whole
No,
vehicle is seized.
that is what the Supreme Court wants.
Hmm.
But it has not gone into the issue of whether.
Issues,
the-
yeah.
the-
Issue has
whether
not been
That
addressed.
provision
Yes.
provides for release of the.
Why 451 is applicable
Under
during
451 during the.
or why
investigation.
457 is applicable during invasion. That is not there.
That has not gone.
So that's why at the outset I said, my lord, there is no direct decision right from the Supreme Court or from other high court except the two which I have referred to. Say
Though
something.
1978, that
Yes.
decision in 1978 has referred to 457.
Yes, to an extent. That's a direct point, my lord. But if we correlate this judgment, my lord, which I have now photostat is probably supplied. My lord, 2010 3 SC, 2010 6 SCC 768.
Yes.
Even though the question in,
Para.
yes, my lord. My lord, para 5 we can straightway go, my lord. In Sundarbhai Ambala Desai's case, the Supreme Court was primarily dealing with the provision of 451 and 457 of the CRPC. While quoting the aforesaid two provision of the Act in the judgment, it was observed in para 7 as under. In our view, the powers under 451 should be exercised expeditiously and judiciously. It would serve various purposes, namely, those purposes have been stated. For these purposes, if the material on record indicates that such article belongs to the complainant at whose house theft, robbery, or dacoity has taken place, then seized article be handed over to the complainant. After preparing detailed proper panchnama of such article, taking photographs after taking proper security, while dealing with the seized vehicle from time to time, the police either in commission of various offense or abandoned vehicle or vehicle which are recovered during investigation of the complaint of theft, the court observes as under. In our view, whatever may be the situation, if no use to keep such vehicles at the police station for a long period, it is for the magistrate to pass appropriate order immediately by taking appropriate bond and guarantee as well as security for return of the said vehicle if required at any point of time. This can be done pending hearing of application for return of such vehicle. Then we can come directly to para 11 and 12. Despite the aforesaid direction having been issued by this court in the aforesaid two matters, grievance is still pending made by the petitioner that the police investigating agency and the prosecuting agency are not taking appropriate and adequate steps for compliance of the aforesaid direction issued by this court. Therefore, the need has arisen for giving further direction so as to clear the clouds and iron out the crease. Notice of the said petition was issued to the state of the Union Territory. Almost all the states have contended that they have already issued necessary guideline and direction for full and complete compliance of the provision contained in section 451 and 457 of the code as elaborated in Sundarbhai Ambala Desai's case, as also under section 158(6) of the MB Act of the Rule as directed by the General Insurance Council case. Thus, in one voice, they have contended that there would not be any difficulty in compliance of the direction that may be issued in furtherance of achieving the objects as directed by this court. Thus, in our view, there appears to be a consensus in this matter. Petitioner has submitted that the information with regard to all insured vehicle in the country is available with the insurance information. That is for insurance matter. Now 14 matter. In our considered opinion, the aforesaid information is required to be utilized and followed scrupulously and has to be given positively as and when asked for by the insurer. We also feel it is necessary that in addition to the directions issued in the court in Sundarbhai Ambala Desai's Ambala Desai Supra, considering the mandate of section 451, read with 457, the following further direction with regard to the seized vehicle are required to be given. Insurer may be permitted to move a separate application for release of the recovered vehicle as soon as it is informed of such recovery before the jurisdictional court. Ordinary release shall be made within the period of 30 days from the date of application. The necessary photographs may be taken, duly authenticated and certified, and a detailed panchnama may be prepared before such release. The photographs so taken may be used as secondary evidence during the trial. Hence, physical production of the vehicle may be dispensary. Insurance would submit an undertaking guaranteeing to remit the proceed for the sale auction of the vehicle conducted by the insurance company. In the event magistrate finally adjudicates that rightful ownership of the vehicle does not vest with the insurer, the undertaking guarantee would be furnished at the time of release of the vehicle pursuant to the application for release of the recovered vehicle. Insistence of personal bond may be dispensed with looking to the corporate structure of the insurer. Now the 15 important. It is matter of common knowledge that as and when the vehicle are seized and kept in various police stations, not only they occupy substantial space to the police station, but upon keeping in the open are also prone to first natural decay on account of weather condition. Even a good maintained vehicle loses its roadworthiness if it is kept stationary in the police station for more than 15 days. Apart from the above, it is also a matter of common knowledge that several valuable and costly parts of the said vehicles are either stolen or cannibalized so that the vehicles become unworthy of being driven to road. To avoid all this, apart from the aforesaid direction issued herein above, we direct the state government, Union Territory, Director General Police shall ensure macro implementation of statutory provisions and further direct that the activities of each and every police station, especially with regard to disposal of the seized vehicle, be taken care by the Inspector General Police of the concerned division, Commissioner of Police of the concerned city, Superintendent of Police of the concerned. So this way, the things are. So taking all this into consideration, my lord, and keeping in view of the matter, my lord, of the judgments of the Allahabad High Court, my lord, that during investigation also the jurisdiction of 457 can be invoked and given into custody.
But the Supreme Court judgment here it only speaks of an ideal situation.
Yes.
You see, sometimes even we pass orders saying that, okay, liberty is given to do this, the writ petition dismiss and liberty to do this as per law. So the ideal situation that the apex court wants would have to fructify through a process of law. Now, so
No doubt about
where is that?
That is not directly coming, my lord. I have said it at the very outset, my lord. We scanned it, we could not find any direct decision that during investigation also it can be given. It is only in game. But if we juxtapose 100 to 3, my lord, then that things comes out a bit, my lord.
Let's go to 457, the provision itself.
Yes. Procedure by police upon seizure of property. Whenever the seizure of property by any police officer is reported, first is reported. Suppose a vehicle, my lord, it can be brought into the court inside, my lord. So it is reported. Constructive custody is said, my lord, to a magistrate under the provision of the court, and such property is not produced before a criminal court during an inquiry or trial. So it is during an inquiry or trial. The magistrate may make such order as he thinks fit respecting the disposal of such property or the delivery of such property to the person entitled to the possession thereof, or if such person cannot be ascertained, respecting the custody and production of such property. If the person so entitled is known, the magistrate may order the property to be delivered to him on such condition, if any, as the magistrate thinks fit. If such direction is unknown, the magistrate may deem and itself in such case issue a proclamation specifying the articles of which such property consists and requiring any person who may have a claim thereof to appear before him and establish his claim within 6 months from the date of such proclamation. So the 457(2) first part, my lord, empowers the magistrate, my lord. To my understanding, I read again for my betterment. If the person so entitled is known, the magistrate may order the property to be delivered to him on such condition. If any, as the magistrate fits, and if such person is unknown, the second part is that unknown. So if a person come forwards, so let's take a situation just to understand this provision, my lord, that a vehicle is stolen, the police chase him, the owner lives, I mean the theft lives, and the vehicle is kept abandoned. Then the police brings it, nobody comes forward. Then the second part, if somebody comes forward, my lord, then the person can ask for the custody, my lord. So otherwise,
From whom?
from the magistrate, my lord. 1 to 102 is always there, my lord. Even the magistrate, my lord. Because the police for all fitness they bring in.
102, let us see 102.
Because it is the police who brings it and it is the police.
102 is only for the, at the stage of disposal.
My lord, the new provision, my lord. Any police officer may seize any property which may be alleged or suspected to have been stolen or which may be found under circumstance which creates suspicion of the commission or any other. So police has been given wide power
Correct.
of seizure, my lord.
Correct.
Such police officer, if subordinate or officer in charge of a police station, shall forthwith report the seizure to that officer. So he will report the seizure. Now comes the amendment part in 1978, that is section 3 and the provision. Every police officer acting under subsection 1 shall forthwith report the seizure to the magistrate, not production, my lord, only report, having jurisdiction, and where the property seized is such that it cannot be conveniently transported to the court, or where there is difficulty in securing proper accommodation for the custody of such property, or where the continued retention of the property in police custody may not be considered necessary for the purpose of the investigation. He may give custody thereof to any person on his executing a bond, undertaking to produce the property before the court as and when required to give effect to the further order of the court as to the disposal of the same. Provided that when the property seized under 1 is subject to speedy and natural decay, if the person entitled to possession of such property is unknown or absent, and the value of such property is less than 500, it may forthwith sold by auction under order. So only 500 is the limit, madam. To
So
unknown.
as per this, the proviso to 1023
Yes, madam.
can be read in tandem with.
With
section,
tandem with 457.
459.
457 also, my lord.
But 459 also invites 457 and 458.
Lastly, if your lordship will.
While
Lastly-
doing 459, 457 and 458 is to be resorted.
Is to be read together.
Yes, lastly, it is written.
So if
madam.
the.
I'll read, madam.
Yes.
Power to sell perishable property. If the person entitled to possession of such property is unknown or absent and the property is subject to speedy and natural decay, or if the magistrate to whom the seizure is reported is of the opinion that its sale would be for the benefit of the owner, or that the value of such property is less than 500 rupees, same provision, madam. The magistrate may at any time direct it to be sold, and the provision of 457 and 458 shall as nearly as may be practical apply to the proceed of such sale. So all these 3 sections are to be juxtaposed, my lord. Then only.
But then this is only with regard to certain property, not to all property.
Only property is said, my lord. Maybe
No, but
movable.
but then it has to, it says here, the
PDM
proviso
is
speaks of whether only if the property is subject.
No,
to
that is
speedy and
perishable, speedy and natural
natural-
decay.
less than 500.
Yes, madam.
uh,
And also relating to certain unknown person, madam.
And yes, so only in those cases. But supposing the property is not subject to
Yes,
speedy decay, then what happens?
So then 457 will apply. madam.
But so that is the question now.
So we have to evaluate it, my lord. no straight jacket formula to say yes or no, my lord. With all the stresses. And the natural justice is of course there, my lord. With this, I conclude my.
My lord, while replying, my lord has just seen the difference between 102 proviso to 3 and 457, 459. Only difference is that 450, 102 proviso is by the police and 459 is by the magistrate. So if my lord peruses 1023 for a
So,
moment,
no, so 459, the magistrate can do it.
yes. Magistrate can do it if it is a permissible. In fact, there is an order I had already placed, my lord, wherein my lord Justice S.K. Mehdi
So the
allowed for
proviso,
auction.
so the proviso to 104, 1023
3
and 459 will go together.
will go together,
And
but
so it
one,
can be done by either.
yes, my lord. It can be done either by the police, if it is at the stage of investigation, that is why it is police, my lord.
And by the court also.
By the court, if it is at the stage of my lord, or at any stage, my lord.
At any stage, at any stage,
459 at
at
any
any
stage.
stage.
So that can be done. In fact, my lord, there is this order in these cases, my lord, wherein my lord Justice S.K. Mehdi allowed auction because these metal nuts were found to be perishable, my lord. While doing so, my lord, 459 was essentially exercised, my lord. So
459 is by the court.
By the
That's
court.
the only, so proviso to 1023 is by the police.
police, exactly, at any stage.
At any stage.
At any stage, because it is subject to natural and speedy decay. So my lord, will
So the
kind-
question, the insertion of the section 457 and 458 in 459 pertains to only how the
procedure
proceeds
is to be, what
the
procedure is to be
proceeds
followed.
are going to be kept.
Exactly, how the procedure to be followed is that, man. My lord, may kindly come to section 102 subsection 3 for a moment, my lord.
Yes.
There is a subtle difference between reporting before a magistrate and producing before a magistrate. 102, my lord, has seen every police officer acting under subsection 1 shall forthwith report seizure of to the magistrate. So it is about reporting to a magistrate, my lord. So till that stage, magistrate is aware that these items have been seized by way of a seizure list. If my lord kindly peruses 170,
But then you see, let us think of a practical situation. When there is a report of seizure of certain goods,
my lord,
and then the court says, okay, keep it in your custody. Keep it in police malkhana or whoever, or in the police station or whatever. Now, at that very moment, does not it become custodial legis in the custody of the
Yes.
court?
custody of the court.
Now, once it is in the custody of the court, won't the court have the power over it?
My lord, that's why, my lord, I wanted to take your lordship to 170 for a moment, my lord.
170.
My lord. My lord has seen 102, it's reporting 170, my lord, can you see? One seven zero. It says, if upon an investigation under this chapter, it appears to the officers in charge of the police station that there is sufficient evidence and reasonable ground as
Just a minute,
aforesaid.
just a minute. I'm still looking at for the
In my barrack, my lord, is
170, yes.
If upon investigation under this chapter, it appears to the officer in charge of the police station that there is sufficient evidence and reasonable ground as aforesaid to take cognizance of the offense under, aforesaid, such officer shall forward the accused under the custody to a magistrate empowered to take cognizance and the offense upon a police report and to try the accused or so on. My lord, I'll skip this. My lord, kindly come to subsection 2, my lord.
Yes.
When the officer in charge of a police station forwards an accused person to a magistrate and takes security for his appearance before such magistrate, under this section, he shall send to such magistrate any weapon or other article which it may be necessary to produce before him. So there may be articles which are not necessary to produce. So it is about production, my lord. And shall require so and so. So that is the difference. If my lord now peruses 451, compares 451 with 457. Only difference is, my lord, 451 is about production and 457 not production. My lord. Reporting is always there because 102 they are duty bound to report. 451, if it is produced during inquiry and trial, 457 if it is not produced during inquiry and trial. For that matter, I would like to take your lordship to the earlier CRPC because that was amended in 1973. This very sections were subjected to amendment, my lord. The earlier the Code of Criminal Procedure 1898, the perimeter provision of 451 was 516A. 16A, this copy, my lord. 516A was 451.
Just a minute. 500.
Stapler to my reason. It's horizontally, my lord, that copy.
No, I don't have any horizontal copy.
सीधा क्या था?
Except this one. This one.
Yes, madam. It was inserted, this 516 was inserted in 1923 and formed part of the earlier CRPC till it was repealed. It is perimeter to 517 with some changes, madam.
Yes.
It says when any property regarding which an offense appears to have been committed or which appears to have been used for the commission of any offense is produced before any criminal court during inquiry and trial. It was consistent, my lord. There also it was inquiry and trial. The court may make such order as it thinks fit for the proper custody of such property pending the conclusion of the inquiry or trial, and if the property is subject to speedy and natural decay, may after recording such evidence as it thinks necessary order to be sold or otherwise disposed of. It was produced during inquiry and trial. Now, my lord will kindly turn to, just for reference, it is not so relevant, my lord. 517 is perimeter to 452, but here we are not concerned with 452. Now, the perimeter of 457, it is 523. It is 523.
Yes.
It says the seizure by any police officer of property taken under section 51 or alleged or suspected to have been stolen or found under circumstances which create suspicion in the commission of any offense shall be forthwith reported to a magistrate who shall make such order as he thinks fit. Thinks fit respecting the disposal of such property or the delivery of such property to the person entitled to the possession. So, my lord, here is the situation, my lord. The police will report immediately, shall forthwith report to a magistrate who shall make such order as he thinks fit. There is no restriction regarding the stage of proceeding, my lord, either investigation, inquiry or trial. It was permissible till that date, my lord, during investigation also. Because inquiry and trial words were missing. Magistrate can immediately pass an order. Then, my lord, before two, my lord.
At 2 o'clock.
My lord.
You're going to make submissions also.
Lordship. Most of my submissions have already been made, only few, my lord, I'll just highlight. My lord.
We'll conclude it today.
Then, my lord, I will give my reply after my learned senior completes, my lord. Today itself.
Yes,
Abhi
hardly
agar
10 minutes. My lord. Not bad.
हमको डाटा देखाই ना किती आहे মই আপুনি হেক কৰে লিখছো
ছুটি মানে নহয় নাচাই ডাঙৰ মানে
sir.
বাকি সবাই লেট কিছুমানে লং লিস্ট কিছুমানে কিবা তাৰপিছত কেইটামান মেনশন
কালি তো মই কলো এইটো সব সেপারেট তো স্যার একটু সুন্দর ভাই স্যার নিজে লিখেছে লাস্ট টাইম ধরে পেপার স্যার ইয়ার আমার अगेंस्ट জীবন সব ঠিক আছে আমার ফেভারিট যেটা হয় এটা সব আমার তার পিছনে যদি কনফিউজ না থাকে एक्चुअली কি বলছো না জাজমেন্ট করতে পড়া হয় লাস্ট কি বলছি নহল মুঝে কনফিউজ আর মই আগে ভাবিছিল সদায় ভাবতে ভাবতে মই ভাবিছিল এটলিস্ট 9:30 পাইলে মই জাস্ট তুমি লোক গাইডটো কিবাতে বুঝিছে কিতাব हाँ जो फोटो फाइल किया से मैं आता फाइल में जानो के गाली दी बता फिर उपाय तो नहीं ना फोटो देते पेस्ट तो माते दी बता गाली कर के चाहिए मैं कुछ भी जितना साफ ना वो सब पॉसिबल सर कोई डोरे टाइप कोई भी देता तो आपको कोई गैस दे को नहीं सबसे देखो यदि आप 3 मत से देते तो मत सोया नहीं दे रही हमारा ऑर्डर से तो ऑर्डर से हेयरिंग में टाइम क्यों नहीं ये पेपर से डॉक्यूमेंट आराम से लगे क्या क्वेश्चन की
Let me judge. First, was gone through the provision of 102 million. The 102 million, that's the power that given to the police by which they can seize any articles. And subsection 3 it says every seizure that has to be reported. Every seizure that has to be reported. Apart from reporting, there's the further power has been given to the police authority to give the custody of the certain goods to my lord the owner thereof as the case they may feel, my lord. Now, my lord, this situation has arisen, my lord, if they do not release, what would be the, my lord, fate of those goods, my lord. The reference that has been, my lord, is before honorable court. Well, if it goes in negative, in that case, there will be no power at all of the court during the investigation period, how so long it may be.
What about 226?
226 is there, 226 there, but
482?
482, I'll have some reservation, but anyway, my lord, I'm not on that, my lord. The plain would be that there will be no power, my lord.
No power in the trial courts,
Trial
in the
courts.
district courts.
But my lord, here the situation, the 457 gives my lord ample power, my lord. The distinction between the my lord 451 and 457. 451 speaks of my lord production of the goods during the inquiry and trial. That much, my lord. And the 457, when any seized article is reported, so that under the code, and this report under the code is under section 1023.
And produce.
And not produced during inquiry and trial. If it is produced during inquiry and trial, 451 will come up. If it is not produced on the basis of the report under the code that has been submitted under 1023, the magistrate will have the power to pass appropriate order for my lord disposal of the goods. And rest, my lord, the provisions of 452, 453, my lord, these are the follow-up actions, how it is to be taken when owner is there, when owner is not there, my lord. Otherwise, lordship may come to 457, my lord. Whenever the seizure of property by any police officer is reported to a magistrate under the provision of the code, and such property is not produced before a criminal court during an inquiry or trial. So it is only the reporting without production in during the inquiry and trial. The magistrate may make such order as he thinks fit respecting the disposal of such property or the delivery of such property to the person entitled to the possession thereof, or if such person cannot be ascertained respecting the custody and production of such property. If the person is entitled, if the person so entitled is known, the magistrate may order the property to be delivered to him on such condition, if any, as the magistrate think fit. And if such person is unknown, the magistrate may detain it and shall in such case issue a proclamation specifying the article of which such property consists and requiring any person who may have a claim thereto to appear before him and establish his claim within 6 months from the date of such proclamation. So this provision gives ample power when the report is submitted before it, under the provisions of this code. So these provisions of the code is 1023, and the goods are not produced during inquiry and trial. So there is no ambiguity between these two sections.
Why not? 102, this did 102?
Yes, madam. Any police officer,
You come to 3.
3, madam. Every police officer acting under subsection 1 shall forthwith report this seizure to the magistrate having jurisdiction. So he has to report. It's a mandatory.
Correct. That's the report. So,
And this report is referred under 457. When a
no,
report
please
is,
carry on reading. Let
yes,
us read.
madam. And where the property seized is such that it cannot be conveniently transported to the court, or where it is difficulty in securing proper accommodation for the custody of such property, or where the continued retention of property in police custody may not be considered necessary for the purpose of investigation, he may give custody thereof to any person on his executing a bond undertaking to produce the property before the court as and when required, and to give effect to the further orders of the court as to disposal of the same. First is, the reporting is a must condition precedent, they have to report.
Correct.
Secondly, when property is cannot be carried conveniently to the by transport or any difficulty in accommodating the custody of the property, or where continued retention of the property in police custody may not be considered necessary for the purpose of investigation, he may give the custody to somebody else
Ah,
or the person.
who?
concerned.
He.
It is the police officer.
Ah, it
Power
is
is-
he.
it
Then-
is- it is the power on the police
Correct.
officer.
Then.
Now question, if he is given, the question of taking the filing an application of court intervention does
No,
not
no,
arise.
the question
Gotcha.
is, under 1023, where is the power given to the court?
Power is 457 because any report is submitted under the code by the police. The
Ah.
report has to be under section 1023. The police-
1023, correct?
Police has to submit a report.
Correct.
Moment report is submitted before the court under 457, court assumes the jurisdiction to disposal of the goods unless if.
Where does it say that? Where does 457 say that?
Yes, madam.
Where? Where does it say that? Even under 102,
Gotcha.
it is reported to the court, but that still the power is not given to the court to dispose of.
That
Give
power is-
custody. It's only
that-
given for disposal, not given for custody. Power has not been given for custody, only
Yes,
for
madam.
disposal.
Madam, even if it is given for custody as well. Madam.
Huh?
Even it is given for custody also.
In
madam.
102,
Yes, madam.
where?
No, madam, not 102, 457.
Where? Where does it give? Where does it say that?
Whenever the seizure of property by any police officer is reported to a magistrate, under the provisions of this code, I refer this report under section 1023. And such property is not produced before a criminal court. That is 451. During inquiry or trial, the magistrate may make such order as he think fits respecting the disposal of such property or the delivery of such property to the person entitled to
Now,
possession.
you see, it says.
Delivery of such property to the person entitled to possession thereof.
Prior to that,
Gotcha.
it says during an inquiry or trial. So that is.
Not produced.
Not produced.
Yes.
If it is produced 451 will apply. Then-
So if it is
So
not,
if it's 457, does the stage of inquiry and trial have to first come before 457 can be applied?
does that has made all the with all respect the submission that has created bit confusion in the area but if your takes up to the word report.
The report, it has to be reported.
So-
Under 102 also it has to be reported.
Yes, my lord.
Under 457 also it has to be reported.
No, that report, what is submitted under 1023 is the report referred to in section 457. That's how the jurisdiction of the court comes, my lord.
No, during inquiry.
And not produced during inquiry. It is not, if it is produced during inquiry and trial, then it will go to 451. May make such order as if think fit respecting the disposal of such property. Or,
Yes, now when you say disposal, what do you understand by the word disposal? Is the word disposal the same as giving custody?
it has also said,
When will the issue of disposal of a property or seized property come into play?
that is disposal, my lord.
So I'm asking you.
Yes, this disposal would come, if it is of the goods are deteriorating fast by natural
So
situation,
disposal
etc.
means what? So disposal means what? You see, giving custody, why do you give custody? So that it can always be brought before the court again later on. It is given on Zima. It doesn't mean that you're giving it away fully. You
No,
keep
but-
it away. Court does not want to see it again. That's not the issue. But in a disposal, when you give something by way of disposing some seized article, it is not with the undertaking that it should be brought back to the court.
No,
It is
no,
for
no.
disposal.
Disposal.
By
that-
way of confiscation, by
Gotcha.
selling or whatever.
That's what 459 is there, I am the second part, my lord, or the delivery of such property to the person entitled to the possession thereof. I'm on that, my lord. Delivery of the property.
Correct,
Of
but
such
then
property
this,
to the
you see,
person.
but then all this thing, this issue with delivery of property, issue with disposal of property, in 457, is there any condition precedent prior to the disposal being allowed by the court or the custody being allowed by the court? Is there any condition precedent, or what is the condition laid down in 457? Or there's no condition? What is your submission?
My lord, if the owner of the goods appear and he satisfies the court that he is the owner of the goods, the custody will be given to him, my lord.
Under what provision?
Well, under this, my lord. The delivery of such property to the person entitled to the possession thereof, because owner is, my lord, definitely a person, my lord, who is entitled to possession thereof. And this part also, my lord, many judgments are there, my lord, even in the Niveda that has been referred by them in one of the paragraph I see, my lord.
Just a minute, on the delivery. But will this come only after an inquiry or trial?
My lord, if it is my lord, during inquiry and trial, if it is produced during inquiry and trial, then it will be under 451. If it is not,
If it is not produced,
it
then
is not produced. So only
No,
the
no,
report
no.
has been submitted.
You see, let us go to this 457.
Rachina.
It says whenever the seizure of property by any police officer is reported to a magistrate.
Yes.
Correct?
Rachina.
Under the provisions of this code.
Rachina.
Now, supposing these words and such property is not produced before a criminal court during an inquiry or trial. Supposing these words were not there.
Rachina.
Then it will read, the magistrate may make such order as it thinks fit respecting the disposal. Then it's fine. Your argument seems fine. But when these words are there, then what does these words bring into the provision? Is it a condition precedent for the, otherwise why was it there at all?
Yes.
What is the point of having a useless word? I mean, useless sentence then. What you're trying to say is that this words and such property is not produced before a criminal court during an inquiry or trial is not relevant with regard to whether the magistrate can deliver custody of a seized property which has been reported to a person. But then the very fact that it is here in the section, why has it been put there? Is it a condition precedent or is it not a condition precedent? What is it?
My lord, this is for the reason that, my lord, report has to be, my lord.
No, forget, not
Yes,
about,
the
I'm
report
not,
has been submitted.
the report part
Yes,
is all right. I'm on this, and such property is not produced before a criminal court during inquiry and trial. Basically, you are saying, your argument is, everything can be done by the magistrate provided that it is reported.
It is reported.
And these words, and such property is not produced before a criminal court during an inquiry or trial, doesn't have any relevance with respect to whether a magistrate can release the property in custody to a person. That's what you're trying to say. In that case, why were these words here? Put it here.
My lord, this, my lord, necessarily, my lord, indicates that, my lord, it is during the period of, my lord, investigation. Because 102, my lord, seizure is during the period of investigation, collecting evidence.
That is what.
Before filing of the charge sheet under section 173. Yes,
but it says, and such a property is not produced before a criminal court during an inquiry or trial. Why is this word here at all? If it is, it's common knowledge that inquiry and trial will only come after investigation. It cannot come prior to investigation. So why was it there at all in the first place?
My lord, in a given situation, it may happen, my lord, the goods have been seized. They have submitted the report. the goods have been released to the the person concerned by the police.
Then,
1023.
then
And the
nothing
person,
wrong.
and in case it is not given, and the person has delayed in approaching the court, in the meantime, the charge sheet has been laid or the goods have been produced in connection with some inquiry made by the
No,
court.
if charge sheet has been laid, then the inquiry has been initiated. That's held by the apex court in Hardeep Singh overall the judgment.
No, that's one. Yes, that's 2014. I have gone through. I'm not contradicting to proposition that has been written, and I cannot, but
No, you see,
here,
even we are trying to understand,
Yes.
okay, so we're not, but the doubts that we have, it's, you'll have to clarify.
Lordship.
So, we're not saying that the doubts that we have is what we are going to hold on to. It's just a way of clearing the cobwebs.
That is there. Now, in this case, to cut short, one of the judgment, that Niveda, one paragraph, I'd like to say where this proposition has been reiterated.
2019-20 SC.
I am referring to AIR, that's the problem. I am referring to AIR.
2019 volume 20 SC.
Which one? Nevada property?
Nevada property.
Para?
Para 16, if you let's see, is taking up AIR, it will be page number 4565 in the middle portion. Section 47 applies when a property has been seized by any police officer and is reported
Just a minute, just a minute. Para 16. Which line?
It will be in page number 4565.
I don't have 4565. You have given me, acha, 4565, yes.
Well, 23rd line on the left side.
23rd line. I don't.
Or we
think-
can
no,
read from the beginning, but it's not
Okay,
much.
please read.
I'll judge. The criminal code can, however, pass
No, no, para 16 doesn't start that way. Para 16 starts with section 451.
I'm on the page 4565.
I'm also on 45, acha, 64, 65.
Yes, my lord.
Para 17 or 16?
16, my lord.
Okay. para
First
16.
line in
The criminal court can.
Lordship, my lord.
Okay. Yes.
The criminal code can, however, pass appropriate order of interim nature as it may be appropriate. What is important and relevant for our discussion is that the sections 451 and 452 are broad and wide, conferring specific and clear powers upon the criminal code, and the language indicates that they could equally apply to immovable property. This section do not make reference to section 102 of code relating to the seizure of the property by the police officer. This is equally true of section 456, which specifically empowers the criminal code to restore possession of immovable property when a person is convicted of an offense attended by criminal force or show force or by criminal intimidation. And it appears to the court that by such force or show of force or intimidation, any person has been dispossessed of the property. The order can be made without prejudice to the right of interest to or in such immovable property which any person may be able to establish in a civil suit. Now, my lord, the section 457 applies when a property has been seized by a police officer and is reported to a magistrate under the provisions of the code, and such property is not produced before a criminal court during the course of inquiry or trial. So, my lord,
So that stage of inquiry and trial has to be reached. Correct. as per what you're reading,
That's it, my lord.
and such property is not produced before a criminal court during the course of inquiry and trial
Yes,
or trial.
yes.
So it has to be reached. That stage has to reach. Is it?
My lord, otherwise also, my lord, it can be, my lord, seen in the other way, my lord, that the state
No,
has,
what are you trying to say?
my lord, for
You,
production.
you have read. What are
Yes.
you trying to say?
My lord, for production before inquiry or trial is not necessary, has not yet come.
For production of
Production of, my lord, the seized article in an inquiry or trial has not come,
has not come.
has not come.
But then it says that section 457 applies.
Applies.
That is the word used.
Lordship, my lord.
Applies when a property has been seized by any police officer and is reported to a magistrate under the provisions of the code, and such property is not produced before a criminal court during the course of inquiry or trial.
Lordship.
So if you say during the course of inquiry or trial, that and to see whether it has been produced or not, during the course of inquiry or trial, that stage of inquiry or trial has to be reached, has to arrive.
My lord, fine, my lord, the one of the section, my friend has read out section 170 perhaps, my lord, when it says just charge sheet is submitted along with the, my lord, everything, my lord, the goods have to be submitted. The seized articles also has
Correct,
to be
correct.
submitted. So
Correct.
question of not producing those goods during inquiry or trial does not arise perhaps, my lord, in view of that particular section
No.
itself.
You see, Aaron, what they are trying to say is that as soon as the stage of inquiry and trial is reached, so whenever the charge sheet is filed,
Yes,
that means the stage
investigation
of
completed.
then the inquiry stage starts. From the date the charge sheet is filed, the inquiry, the stage starts. And if the property seized is not produced along with the charge sheet, then the magistrate has the power to release custody of those goods. Basically, they are saying that magistrate has the power to release those goods under 457 only after charge sheet is filed, only at the time charge sheet is filed, not before that.
So, my lord,
And 457, the way it has been stated here, appears to show that 457 will apply when the seized property is reported to a police officer and the property is not produced at the time of filing of charge sheet.
but those will be added, my lord, those will be added words, my lord, into the section.
No.
457.
No. Hardeep Singh has said in the
My lord,
Supreme
even
Court.
if in that case, my lord,
In-
instead of using these word, could have said, my
No.
lord, the
This
charge-
is the interpretation by the Constitution bench of the Supreme Court, not by me.
No, my lord, that I have gone through. My lord, Lordship has also, my lord, discussed earlier. My lord.
Yes.
Yes.
So I'm just for simple, in simple English, I'm just putting it. Otherwise, in simple, otherwise I could have said inquiry at the start of the inquiry. Instead of that, to make it more understandable, I'm just saying at the time of submission of charge sheet, because inquiry starts from the date the charge sheet is submitted.
That's it. So, my lord, for the preparation of the charge sheet, that particular section, my lord, says all the goods seized or the seizure list, whatever, my lord, everything, documents, everything has to be submitted before the court under 173, that is the charge sheet. So question of non-producing those goods into this charge sheet, my lord, does not arise because they have to produce it, my lord. That is the mandate of that
No,
section.
they don't have to produce. 457 says no, they don't have to produce it. In
No.
fact, when they don't produce it, then the power has then the court has the power to give custody.
My lord, my lord, intervention, because my lord, some purpose has to be given to my lord, because the if the reference goes negative, the court will have no power at all under 451 and 457. Coupled with this, the objective of the particular this chapter 34, what has been laid down in Basapcom case, followed by this Sundar Bhai Ambali case. In this, there the Basapcom case, the object of the chapter 34 has been given that goods have to be released as fast as possible.
Correct, but without going into the issue
Yes,
of the provisions
exactly.
of 457.
Lots of matter.
You see, that is the ideal situation. That is what the apex court has held should be done.
And
But
it
whether it can be done
is-
as per the law, by interpreting the law is a different issue.
Yes. This paragraph 4 of that judgment, it says direct or indirect control. The court has direct or indirect control over the every action of the police.
Correct.
So here also submitting a report, not necessarily the court must authorize them to have the custody. If they're apparent on the face of the court, it founds that the seizure is illegal or whatever, it is not that as without application of mind, the court will simply authorize them to retain the property.
No, but then you see, there is also in Tulsi Ram Patel, the apex court has held that when you're going to do some act, the existence of power has to be there
Yes,
to do that act.
yes.
You cannot do something in vacuum. There has to be a source of power for exercising that power. So where is that source of power here?
This moment it is reported, now the court is obliged to pass some order on it.
Correct.
It may not be always the police is allowed to take the custody.
Correct.
Police, the court may not authorize also.
Correct.
And that is the situation where the owner comes and submits his all documents that he is entitled to the possession. Not necessarily that the goods have to be given to the police. That 457 says if the person entitled to possession is to the satisfaction of the court.
So that is the very issue that is before this court, is whether the power has been given to the court to release seized articles into the custody of some person during investigation. Where is the source of power?
That one, madam, for a moment, my lord. What I see, my lord, this 457 also does not speak, my lord, after the section 1023. But what I find, it is the only section 457. And I find no other section, my lord, whereby it has been said that once report is submitted, it will be just in the record. Or that the court will, my lord, authorize the, my lord, police to retain the, my lord, custody. That power is, my lord, as it, my lord, appears, my lord, it exists in section 457. They may authorize them to retain the property. They may also say to produce it on a particular day. It may also inquire, my lord, what happened to those goods. They have to say that these goods have been released and under section that, my lord, provision. So, my lord, the power is inherent, what I find, my lord, under section 457. If they can authorize, my lord, the police to retain it, the court has also the power to, my lord, give it to the custody to the person who is best entitled to the position. And looking at the, my lord, that Basavacom, my lord, section paragraph 4, my lord, the object, it has come. It says, my lord, directly or indirectly, all the actions of the police under the control of the, my lord, court.
So that way,
the police.
So then, in that event, the criminal courts should release custody of seized articles on the basis of that order passed by the Supreme Court and not on the basis of the CRPC.
No, my lord, that limb of argument, my lord, say, my lord.
No, because
the clear-cut rule did not exist. in my lord, this Sundar Bhai case, my lord, that
No, no,
was.
you see, because the Supreme Court there has said, yes, 15 days, 30 days, it should go.
That's it, my lord.
Very well. Where does it provide in the CRPC that it can be done as is desired by the apex court?
My lord, when the act or the provision is, my lord, silent, perhaps, my lord, the Supreme Court direction would be, my lord, would be binding on the, my lord, authorities. And in this fact, my lord, in fact, all the, my lord, registry of the High Courts were directed to make some rules, my lord. there.
So the Supreme Court judgment would be the source of power for exercise of that power. There has to be an existence of power to exercise
No,
it.
the source of power is 457. Why I am saying, my lord, the one of the ground, my lord, in one of the cases rejected by the honorable single judge, that 457, the section 457 has not been mentioned in the Sundar Bhai case. It is only deals with the 451. That is one of the, my lord, order, my lord. But this has been clarified by the subsequent, my lord, judgment of the apex court that this is the rules or the guidelines framed by the apex court. And it has to be followed. And in fact, the state government, various state government has submitted that they have made the rules. My lord, in that Sundar Bhai case, my lord, the direction have been issued to the magistrate to act accordingly, my lord. The Sundar Bhai case also. The proposition or the conditions that.
To act accordingly. Okay, yes, but then that is the very issue. Okay, it has to be acted, but it has to be acted as per law.
Well, because these had to be formulated because there was a submission from both the sides that there is no specific rules as such or clear-cut guidelines as such for how to deal with the seized property. So therefore, referring to section 451 and 457, the certain guidelines have been framed. And if you also goes through those guidelines, these are some are falls under 451 or 457 as the case may be, because some are during the inquiry or trial or some are prior to that. And this particular reference of only 451 that has been subsequently clarified by the court that this is the guideline framed by the Supreme Court under the to deal with the property under section 451 and 457. The various High Court also interpreted in that line, my lord. So if that be so, my lord, the magistrate is bound to act, my lord, as per the direction therein, my lord, 141 of Constitution.
Anything else?
My lord, that 2000, that Sundar Bhai Desai case, has gone through. Paragraph
Which citation?
2002-10 SCC 271.
2010, 2 SEC,
2002-10 SCC 271.
271, yes, para?
Paragraph 3, my lord.
Paragraph 3.
Well, I just read out, my lord, this, my lord. At the time of hearing of these matters, learned counsel for parties submitted that various articles are kept in police custody for a long period by not adhering to the procedure prescribed under CRPC, which creates difficulties for keeping in safe custody. Finally, the sufferer are either the state exchequer or the citizen whose articles are kept in such custody. It is submitted that speedier procedure is required to be evolved either by the court or under rule for disposal of mud mammal articles which are kept in various police stations, as most of the police stations are flooded with seized article. It is therefore submitted that direction be given to so that burden of the court as well as the police station can to some extent be reduced, and that there may not be any scope for misappropriation or of replacement of valuable articles by spurious articles. Then, my lord, after 451 and 457, my lord, the paragraphs 7, it has been said, in our view, the power under section 451 of 451 CRPC should be exercised expeditiously and judiciously. It would serve various purposes, namely, owner of the article would not suffer because of its remaining unused or by its misappropriation. But this falls, my lord, under, my lord, before, my lord, inquiry or trial, as well as during inquiry or trial. Then, my lord, the court or police would not be required to keep the articles in safe custody, both during investigation or, my lord, inquiry or trial. The proper panchnama before handing over possession of the articles is prepared that can be used in evidence instead of its production before the court during the trial. If necessary, evidence could also be recorded describing the nature of the property in detail, and this jurisdiction of court to record evidence should be exercised promptly so that there may not be any further chance of tampering with the articles. Now, my lord, with regard to the 19 regarding, my lord, the seized articles, liquor, etc., my lord. Now, paragraph 21 says, my lord, however, these powers are to be exercised by the magistrate concerned. We hope and trust that the magistrate concerned would take immediate action for seeing that power under section 451 CRPC are properly and promptly exercised and articles are not kept for a long time at the police station, in any case for not more than 15 days to 1 month. This object can also be achieved if there is proper supervisory by the registry of the High Court concerned in seeing that the rules framed by the High Court with regard to such article are implemented properly. Now, my lord, this reference to only 451, this has been clarified, my lord, in the (2010) CRLJ 2883. General Insurance Council
2010
CRLJ 2883.
CRLJ
2883.
Which High Court or Supreme Court?
It's Supreme Court. I'm just referring. Well, this SCC citation, perhaps already Lordship has Senior Counsel Jet Kamar had referred to, my lord.
Party number.
Now, reading, my lord, paragraph 1, my lord. Even though the question projected in this petition filed under Article 32 of the Constitution of India is then answered by judgment of 2 learned judges of this court reported in 2002-10 SCC, AR so-and-so, titled Sundarbhai Ambala Desai, State of Gujarat, pertaining to interpretation and mode of implementation of section 451 and 457 of the Code of Civil Procedure 1973. Court has accepted, my lord, that there was an interpretation not only with regard to 451 but also with regard to 457. The subsequent Then again in paragraph 5, Sundarbhai Ambala Desai Air 2003, the Supreme Court was primarily dealing with the provision of section 451 and 457 of the code. Then, my lord, paragraph 11. Despite the aforesaid directions having been issued by this court in the aforesaid 2 matters, grievances is still being made by the petitioner that the police investigating agency and the prosecution agency are not taking appropriate and adequate step for compliance of the aforesaid direction issued by this court. Therefore, need has arisen to giving further directions so as to clear the clouds and iron out of creases. Notice of the said petition was issued to all state and union territories. Almost all the states have confined that contended that they have already issued necessary directions, guidelines and direction for full and complete compliance of the provisions contained in section 451 and 457 of the code as elaborated in Sundarbai case. Does, does in one voice, they have contended that there would not be any difficulty in compliance of the direction that may be issued in furtherance of achieving the object as directed by this code. So Supreme Court direction has been, my lord, interpreted to have, my lord, not only confining to, not confining to 451, but for, my lord, 451 and 457. And compliance of that was mandatory, that violation of which has been agitated before the court.
I do not know. We do not know how this helps you, the judgment.
Because the direction in Sundarbhai case, as I, my lord, pointed out, this is for both, my lord, 451 and 457.
Maybe 454, 147, but where is, let's go down again to the issue at hand. Where does 457 allow you?
On that, my lord, I have already, my lord, my submission, I have already, my lord, made that the report under the code which was submitted before the court
That gives the power.
and not produced before the during the inquiry and trial.
So this is what.
That's it, my lord.
So your submission is basically that the stage of inquiry and trial would have to first arrive prior to the court having the power to release the goods. So your submission is.
My submission is other way, my lord. I said, my lord,
Because
the inquiry and trial has not commenced.
Your submission should, your case is basically that that at the investigation stage under 457 it can be released by the court.
Yes, yes.
However, when you're reading it and the manner in which you have submitted your submission, it amounts to saying that at the investigation stage it cannot be done because the stage of inquiry and the trial has to first arrive.
My lord, that's what, my lord, my submission is other way, my lord. What I am submitting that if the, my lord, trial or the inquiry or the trial would have commenced, the question of non-production does not arise. So prior to that stage, when there's no inquiry or trial, because this during this inquiry also many things, my lord, the court may direct them to produce also. So therefore, my lord, if it is not produced,
out there is no hassle, there is no problem because the issue is if those words were not there, inquiry and trial in 457, then what would be the import of the said section? And with the inclusion of those words in the said section, now what is the significance of those words and does it change the import of that section 457?
If both these sections are read together, my lord, 451 and 457, there may be a case, my lord, during the investigation period when report was submitted, the court did not release the goods. And then, my lord, again, the goods have been produced during inquiry and trial. The court will, because once already that has been rejected. So therefore, the new cause of action has arisen on the court to, my lord, pass an order, my lord, giving custody, my lord.
I'm getting confused.
But I am on the, my lord, purposive, my lord, interpretation on that point, because, my lord, otherwise, as I said, my lord, from the Basapcom decision, what it says, my lord, the very purpose of the object of particular chapter, it has been said, my lord, that it cannot be, my lord, for a moment, my lord, I just read out, my lord, one paragraph, my lord, of that section, judgment, my lord. Paragraph 4, my lord.
Paragraph 4. Which paragraph? Which case?
My lord, it is 1977 4 SCC 358. And I'm just submitting that Basapcom case, which has the reference in the Sundarbai case, my lord.
Yes.
The object and scheme of the various provisions of the code appear to be that where the property which has been the subject matter of an offense is seized by the police, it ought not to be retained in the custody of the court or of police for any time longer than what is absolutely necessary. As the seizure of the property by the police amounts to a clear entrustment of the property to a government servant, the idea is that the property should be restored to the original owner and the necessary to retain in seizures. It is manifest that there may be two stages when the property may be returned to the owner. In the first place, it may be returned during an inquiry or trial. This may particularly be necessary where the property concerned is subject to speedy or natural decay. There may be other compelling reasons also which may justify the disposal of the property to the owner or otherwise in the interest of justice. There may be other stages also. The High Court and the Session Judge proceeded on the footing that on the essential requirement of the court is that the article concerned must be produced before the court or should be in its custody. The object of the court seems to be that any property which is in the control of the court, either directly or indirectly, should be disposed of by the court, and a just and proper order should be passed by the court regarding its disposal. In a criminal case, the police always acts under the direct control of the court and has to take orders from it at every stage of an inquiry or trial. In this broad sense, therefore, the court exercises an overall control on the actions of the police officers in every cases where it is taken cognizance. When report is submitted, the court takes a cognizance because it applies the judicial mind. This case speaks not only of the inquiry and trial, but also for ends of justice for
No, you see that second last sentence. In a criminal case, the police always acts under the direct control of the court and has to take orders from it at every stage.
Every stage of an inquiry or trial.
If it inquiry or trial. Doesn't talk of investigation.
There's two proposition it has said. One is inquiry and trial, and other is the reasons that what is said. It is manifest that there may be two stages when the property may be returned to the owner. In the first place, it may be returned during any inquiry or trial.
During any inquiry or trial.
Trial.
Not during investigation.
Yes, but this may particularly may be returned during any inquiry or trial. This may particularly be necessary where the property concerned is subject to speedy or natural decay. There may be other compelling reasons also which may justify the disposal of the property to the owner or otherwise in the interest of justice.
So, it doesn't give the stage. The stage is verified here.
That's what
Will the court have any power over the investigation being conducted by a police?
Court has lodged, my lord. My lord, if a
I think we have got zero power.
My lord, if a second FIR is lodged, first FIR is pending. In that case, my lord, leave of the court has to be, my lord, obtained to, my lord, register it separately. Otherwise, it has to be, my lord, taken as a, my lord, the supplementary information. Or even after submission of the, my lord, of course, that is, my lord, at the second stage, my lord. But it is there, my lord. And every, my lord, even, my lord, this chapter, my lord, 7, my lord, search and seizure, all these, my lord, proceedings are there, my lord. The court's order is necessary for obtaining a search warrant or, my lord, the warrant of arrest, proclamation, etc. my lord. This is during the investigation. The court's intervention is necessary. And finally, my lord, what I submit, my lord, since the Sundar Bhai case has been, my lord, subsequently, my lord, in the 2006 case, my lord, that General Insurance Company, my lord, it has been said that the rules have been framed by the Supreme Court in the earlier case. These are to be followed, my lord, and same view has been adopted by various high courts, my lord. It has been taken as a, my lord, rule, my lord, for the purpose of, my lord, deciding petitions under my lord, the custody under section 451 and 457.
Which one?
My lord, these conditions laid down by the, my lord, in the, my lord, Sundar Bhai case, my lord. It has been accepted by, as I have already shown, my lord, the Supreme Court has also, my lord, said it is a guidelines under 451 and 457. Similar view has been, my lord, taken by various high court also, my lord. And accordingly, rules are framed for whatever, my lord, but they have been doing it, my lord. And those guidelines is not confined to only a situation 451 or 457.
I would start with Sundar Bhai Ambala, my lord, 2002 10 SCC. Sundar Bhai Ambala, my lord, the Supreme Court had no occasion to decide on the issue which my lord is now deciding, because there was a case pending trial. Paragraph 2 of the judgment, my lord. May I read? Everybody has started from 3. If we read paragraph 2, the factual position therein was that, my lord, trial was on. It is the prosecution version that an FIR lodged on so-and-so by Assistant Commissioner of Police D Division Surat that the petitioners and other police personnel are involved in offences punishable under section so-and-so of IPC. It is alleged that when they were working at various police stations, they had committed offences during the period from 92 to 2001 by replacement of Mudamel's articles, including golden ornaments, by other spurious articles, misappropriation of the amount which was kept at the police station, unauthorized auction of the property which was seized and kept in police custody pending trial. There was a trial pending that case, and in that even that.
You would say that we say started with 3.
You see, pending trial.
That was pending trial. So Sarsi was already
Pending
filed.
trial. How do you know that there was an inquiry? How can you say that it was in the inquiry stage? How do you say that?
That is with pending trial, my cognizance has already taken, my lord. That's why the word is pending trial. It's not pending
trial.
inquiry or pending investigation also, my lord. Paragraph 5, my lord. Paragraph 5 of the judgment, while taking note of section 451 and 457, says, my lord, section 451 clearly empowers the court to pass an appropriate order with regard to such property, such as for the proper.
No, you see, because if you look at the definition of inquiry,
My lord,
inquiry means every inquiry other than a trial.
my lord.
So,
it's-
so when it says pending trial, it could be an inquiry, and would inquiry also encompass investigation?
No, cannot be, my lord.
Because of the judgment. of the district.
Investigation and inquiry separately defined. At least, my lord, assuming inquiry was pending, but investigation was not pending, or else, my lord, court would not have used the word pending trial, because to pending trial, my lord, cognizance has to be taken. In a particular case, cognizance may not be taken also, my lord. Then in that same judgment, my lord, paragraph 5, it says, section 451 clearly empowers the court to pass an appropriate order with regard to such property, such as for the proper custody pending conclusion of the inquiry and trial. Sundar Bhai Ambala itself, my lord. Paragraph 5. Then, my lord, that quoting the Basava case, my lord has just now seen, my lord, Basava case, Supreme Court has clearly held, my lord, the control over investigating agency comes when the stage of trial and inquiry begins, trial or inquiry begins, not at the stage of investigation. Because as per section 156(3), the magistrate power, we are not talking about, my lord, code under 226, my lord. It's a criminal court's power of during investigation is to, my lord, direct the police to conduct an investigation, not to conduct an investigation in a particular way. My lord, may I kindly peruse section 156(3) for a moment, my lord.
One 63,
156, my lord.
156.
Police officers' powers to investigate cognizable offence.
Yes,
Any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable offence case which a court having jurisdiction over the local area within the limit of such section would have power to inquire into or to try under the provision of the chapter 3. Subsection 3, my lord, will kindly see. Any magistrate employed under section 190 may order such an investigation as mentioned above, but not the manner in which the investigation is to be conducted. That means registration of a case. After applying mind on a complaint petition, the magistrate can ask for registration of a case and investigate, but cannot direct that you do investigation in this manner. Now, my lord, I will.
just a minute. Man. Yesterday, the other day you were saying
My lord.
that that reporting of a seized property is required to be done by the police officer to the court in terms of
102, 102.
no, and then what about you're saying 173 CRPC also? 167 and 163. What were you saying regarding 167 and 173 CRPC?
I was relying on those provisions wherein, my lord, it was said, my lord, that investigation, if cannot be completed within 24 hours, then a person can be detained for a different period depending upon their, my lord, nature of the offense.
Correct.
So the legislation, my lord, intended or expected that the investigation usually will be concluded in 24 hours. That is why, my lord, custody at the time of investigation was not granted to the criminal court. I will come to it, my lord. 102, my lord, has seen, my lord. It is to be reported.
Yes.
Now, my lord, will kindly say 170. Says, my lord, this is what I was on that day. 173. 170 subsection 2 says, when the officer in charge of a police station forwards an accused person, 170 subsection 2, my lord.
Yes.
When the officer in charge of a police station forwards an accused person to a magistrate and takes security of his appearance before a magistrate under this section, he shall send to such magistrate any weapon or other article which is necessary, which may be necessary to produce before him. So what is to be reported and what is to be produced, my lord? Reporting is of every seized item. Production is of the items which may be necessary for trial. Suppose as a police officer, I have seized, my lord, hundreds of documents. I am not relying on the other document, I am relying in 10 documents. Why will I produce in trial, my lord, along with my charge police report?
Correct. Then give the 92 in custody.
Then, so that is why, my lord, the section 457, if we go again, it says not produce. That means it may not be required for trial. If it is produced, it is 451, it is required for trial. And if it is not produced, it is not required for trial. 451, my lord has seen. It doesn't say.
It may be required, but due to the bulkiness, it might not be able to be brought to the
That
court.
is what that is also one aspect, madam.
Huh?
That is also one aspect of this matter, madam. Production or not production.
No, my lord, he is confusing, my lord, because of the fact, my lord, with all respect, after intervening it, because it's not in the proposition. Investigation, my lord, at that time, there is nothing of giving that 10% will be required, 90% will not be required. It is 90 and 10% will be required when he will file the charge sheet, the documents which he will rely upon. that this instrument I'll rely upon, these documents I'll rely upon. At the time of investigation, the police has wide power, and that field is exclusively reserved for the investigation. No court can direct it, that the manner as to how to investigate. But now, if a person is taken into custody, he will be remanded, bail petitions will be there. All these are the process of the court, my lord, empowered by the court. But so far, the charge sheet is submitted. Then only the legal documents that they will produce will be taken into account. Rest will be left out. It's not that in investigation everything is taken and you will not get it. That is not the scheme of the CRPC, my lord. Police has got the power to collect everything, my lord. What they will rely upon after filtering it out, my lord, the police will rely upon these certain documents, my lord. That's why I pointed it out, my lord.
My lord, let me argue. One difference is, my lord, in 451, my lord. I will read for a moment, my lord. 451 says, when any proper. It's very difficult to argue, my lord.
I can't even direct my assistant. Oh, what wrong I said, right?
I don't know, it's between you two.
No, man. We in corridor we are different, man.
Anyway, my lord.
You all will go out after this, go have a cup of tea
Yes,
together.
that's the beauty of this profession, man.
That's the
He
beauty.
himself was saying in the lunchtime when he said something.
Well, I'll come to 451.
Sure, go ahead.
When any property is produced before any criminal court during inquiry or trial, the court may make such order as it thinks fit for the proper custody of such property pending conclusion of inquiry and trial. It is conclusion of inquiry and trial. And if the property is subject to speedy and natural decay, or if it is otherwise expedient to do so, the court may, after recording such evidence as it thinks necessary, order it to be shown. So recording of evidence is also a condition precedent in 451, which is absent in 457, because the items that are not produced before the court during trial and inquiry are not of no use in trial. That is why it can be easily granted. Now, my lord, I had the first of my lord, I had taken your lordship to the 1898 CRPC. That is very relevant, my lord. Why these changes? Section 516A. 516A was, my lord, is, my lord, perimeteria.
Why are you giving us small slips of paper?
That will be the last
separate?
page, 550, my lord.
Huh?
That will be the last page of the earlier CRPC, my lord. 1898 CRPC, my lord.
Just a minute, where is the idea? We've got a bunch of petition papers now.
Code of Criminal Procedure,
So
1898.
this is in the last page.
Last page. Stapler.
Stapler, have you got stapler?
My lord, I have a book, my lord, your lordship.
No, it's okay, it's okay. I will relying from them. Whenever he will argue, my lord, he will give that book.
It is written the same thing.
There is one copy of hard copy. I can move it there. It's a division bench.
No, there are two copies.
Yes.
516, my lord, is perimeter to 451 here, my lord. It says, when any property regarding which any offense appears to have been committed or which appears to have been used for the commission of any offense is produced before any criminal court during inquiry and trial, same thing, my lord, inquiry and trial, the court may make such order as it thinks fit for the proper custody of such property pending the conclusion of the inquiry and trial. And if the property is subject to speedy and natural decay, he may, after recording such evidence as it thinks necessary, order it to be sold or otherwise disposed of. It is during inquiry and trial, it is produced. So then, my lord, 517 is perimeter to 452. We are not, in this case, concerned with 452, my lord. Just to indicate, my lord, 452 is perimeter to 517. Now, my lord, 457, my lord, was 523 in the earlier code. The seizure by any police officer of property taken under section 51 or alleged or suspected to have been stolen or found under circumstances which creates suspicion of the commission of any offense shall be forthwith reported to a magistrate who shall make such order as he thinks fit respecting the disposal of such property. So there was no restriction regarding the stages like investigation, inquiry and trial. On production, magistrate could, on reporting, my lord, magistrate could pass any order at any stage. Now, my lord, law commission. My lord, in 41st report of Law Commission of India, my lord, by which thereafter, my lord, new CRPC came in.
How many loose sheets are you going to give us?
This is the Law Commission report, my lord. I'll do one thing, well,
You make a compilation and
Well,
we're having so much of papers now, all, you know.
I'll do one thing, my lord. I will prepare a written argument and supported by all in chronologically, my lord. I'll give a compilation, my lord.
Because it becomes very difficult for
Difficult.
us. Otherwise. We have to staple ourselves also, the sheets here and there. Yes,
My lord, page 334. This is the report of Law Commission.
page 334 of the Law Commission.
Paragraph 43.4. Section 516A,
Just a minute, just
My
a
lord,
minute.
my
There
lord.
is Page 300, oh my God.
334.
It's very,
at the top, my lord. I'll be relying only on two paragraphs, my lord.
your photocopies also, page 334.
At the top of the page, it is there, my lord. Section 516A does not cover all property that comes into possession of the court for the purpose of an inquiry or trial. For instance, property which is produced merely as evidence of crime is not covered. In many states, express provision for the disposal of such property is not necessary, since the High Court rules provide for interim custody and final disposal of all documents and articles produced before any court for the purpose of evidence. These are marked as documentary exhibits or material exhibits, but it will be noticed that this class of property is expressly mentioned in section 517(1). There may be some states where the High Court rules do not provide for the custody of and disposal of such property. We therefore suggest that section 516A should be made comprehensive so as to include material and documentary exhibits in the case which may not have been used for the commission of the offense and regarding which no offense may appear to have been committed. The opening clause of section 516A may accordingly be amended and to read, and when any property is produced before any criminal court during inquiry or trial. Now, my lord, turning to this 523. At page 341. Same document, my lord.
341.
341. Well, the last clause at the bottom, 43.27.
Yes.
Section 523(1) deals with two different matters. First, it lays down the seizure of property by a police officer shall be forthwith reported to a magistrate in certain circumstances, and then it goes to provide for the disposal of such property by the magistrate. Seizure of property is to be reported by the police officer when it is either under section 51 upon searching an accused person, or under section 550, which empowers any police officer to seize any property which may be alleged or suspected to have been stolen, or which may be found under circumstances which create suspicion of the commission of the offense. There are various other sections in the code which also empower the police to seize property during the investigation of an offense, and most of these provisions contain the requirement that the police officer should report the seizure to a magistrate. It would therefore be better if section 523(1) generally referred to all cases where seizure of the property by a police officer is reported to a magistrate, and not only the seizure under section 51 or 550. Where such property is produced before any criminal court during inquiry and trial, it will be dealt with under sections 516A and 552. 516A to 522. This class of property may be excluded from the scope of 523. This subsection may accordingly be revised as: whenever seizure of property by a police officer is reported to a magistrate under the provisions of this code and such property is not produced, So there are two classes from 516A to 550, 522. It is when property is produced during trial and inquiry, and 550, 523 when it is not produced. Difference is only produced and not produced during trial and inquiry. Both are during trial and inquiry. So this is, my lord, exactly in total. Now it is 457. This suggestion has been accepted. This is the 457 now. Whenever the seizure of property by any police officer. Now, my lord, coming to the last page, my lord, section 102, my lord, stood as 550. Last page of that document, my lord, just
Yeah.
550 down below, my lord.
525.
550, my lord. Oh, sorry, that's CRPC one, my lord. The old CRPC. Last document, my lord. 550, power of police. Oh, power of police to seize property suspected to be stolen. Any police officer may seize any property which may be alleged or suspected to have been stolen, or which may be found under circumstances which create suspicion of the commission of any offense. Such police officer, if subordinate to the officer in charge, shall forthwith report the seizure to that officer. This was only 102 at that point of time, 550. No power of police for giving custody, not even for property which may be subjected to speedy or natural decay. That is why, my lord, in the new CRPC, the remaining part has come in 102 subsection 2(3) proviso to 3. So that during that period, my lord, these properties can be protected by the investigating agency itself. It was silent at that time. Excellent.
Okay, this 102 speaks of disposal.
Disposal.
When is the stage of, what do you understand by the word disposal?
My lord, it may be, my lord, by auction, it may be by confiscation, it may be giving it to the person concerned.
That is after the trial or prior to the, can it be done prior to an inquiry?
102 is purely during investigation. It is by the police officer. It is not by the court.
Are you sure? Please read the word disposal in 102.
Second part, court. Proviso.
102 subsection 3, my lord.
There.
Proviso.
ইমান ইন্টারফেয়ার কে করে এটা কবুটি Every police officer acting under subsection 1 shall forthwith report the seizure to the magistrate having jurisdiction, and where the property seized is such that it cannot be conveniently transported to the court, or where there is difficulty in securing proper accommodation for the custody of such property, or where the continued retention of the property in police custody may not be considered necessary for the purpose of investigation, he may give custody thereof to any person on his executing a bond undertaking to produce the property before the court as and when required, or to give effect to further orders of the court as to the disposal of the same.
So disposal is to be given by the court.
No. Assuming, my lord, we have police will give.
And to give effect to the further orders of the court.
Yes, further orders of the
As
court.
to the disposal of the same.
Exactly. For example, my
So
lord,
this will be with regard to what?
police will be giving custody
Ah,
to the person concerned. Then the trial started
correct.
or inquiry started. Any order passed under 451, 457, police has to comply with this, my lord. The person concerned has to comply with this.
So I am asking you, this disposal, the word disposal that has been used in 451,
Yes,
now in 102,
my lord.
does it relate to an order of the court
That
for
will be
disposal?
that will be passed later on in 451 or
I'm just asking, whether
Yes, yes.
it be passed
Yes.
later on or before, that's a
yes,
different
yes,
thing.
yes, my lord.
Whether 1023 talks of disposal order to be passed by the court or by a
Court.
police officer,
By court, my lord.
by a court, correct?
As to the disposal of the same, by court.
Now, so my question is, this disposal will occur when? When will it occur? When will the stage of disposal occur?
451, 457 at the stage of inquiry or trial, 452 post trial, my lord.
So the word disposal, so that disposal of the seized article will occur when after the inquiry,
After the inquiry, my lord.
after the inquiry,
That-
after the inquiry or, okay, and not at the investigation stage.
Not at the, because at the investigation, suppose custody of a vehicle is granted to a person. In the trial, it is found that he is not the owner.
So,
Any order passed
So-
under 102
so-
will be
so-
subject to 450.
so a police officer cannot give an order of disposal.
Absolute custody, he cannot, absolute.
No, no, let us be, I'm not talking about absolute. Why are you putting words into, kind of, I'm saying the word disposal. You're saying absolute custody.
He cannot
The
dispose,
word
madam.
used here is disposal. It's a question put to you.
Yes, my lord.
Can a police officer give an order of disposal of a seized property?
No, he can give custody only.
He cannot give disposal, correct? So the disposal can only be given by a court.
Court.
And as per your understanding, disposal cannot be given during the investigation stage.
Exactly.
It can be given only
Custody.
after, only at the inquiry or trial stage. Correct?
Exactly. If, my lord, it is, but proviso is there, my lord. If it is subjected to necessary decay, my lord, then, my lord, it can be auctioned, my lord.
That proviso is there.
That is perimeter to 459, my lord. Almost.
459. correct.
Authorities are different, my lord.
500.
Now, my lord, that 77 4 SCC. My lord,
What is this?
that judgment, my lord, 78 2 SCC 491,
This 1978
2 SCC,
2 SCC
uh, 2 SCC 491, my lord.
491. Yes.
Ram Prakash Sharma case, my lord.
Yes, yes.
In that case, my lord, as seen paragraph 5, it says, in reaching the conclusion, we have taken note of the decision of this court in Vasava Com Daya Mongda Patil versus State of Mysore. That is 77 judgment, my lord, which was already placed, my lord. That is 77 4 SCC 358.
Correct.
In that case, my lord, what was the fact? In that case, basically, court has said that custody can be granted during inquiry and trial. I will read that line, my lord. It is manifest that,
Just a minute.
my lord. Paragraph 4, my lord.
Just a minute. I'm still looking for the judgment.
You will find in the compilation page 52.
No, that 1977 judgment.
77
I
4
have
SCC.
given it.
I have also given.
You have it.
Yes.
Just a minute. See, we've got so many papers now.
Yes, absolutely, very confusing. It should have been compiled.
We've got another- Yes.
77 4 358, para 2 and 4, my lord. 2 is on facts, my lord. What was the facts in that case?
Yes.
Paragraph 2. It appears that a theft took place in the house of the complainant appellant on the night of November 28, 29, 1958, in the course of which a large number of ornaments and cash, etc., were stolen from the possession of the complainant appellant. On February 8, 1959, a number of stolen articles were recovered from accused number 1 to 5, and various panchnamas evidencing recovery of those articles were prepared. On February 10, 1959, the articles seized by the police from the possession of the accused were identified by the complainant at the test identification period, and ultimately a charge sheet was submitted against the 5 accused on February 20, 1959. The articles were produced before the court of the Chief Judicial Magistrate, who directed the police officer concerned to return the articles in his custody, to retain the articles in his custody until the same were verified and their values were determined by a goldsmith. The court moved the higher authorities for obtaining sanction of the necessary funds for payment of fees to the goldsmith. Therefore, the articles were kept. Thereafter, the articles were kept by the sub-inspector Haveri in the guard room of the police station in a trunk with a list of the articles and the corresponding entry in the concerned register. Towards the end of the year, the sub-inspector was transferred and his successor took charge of the post of the sub-inspector Haveri and also verified the articles kept in the trunk on December 23, 1959. It is not disputed that the new sub-inspector, after taking charge, found the articles in the trunk intact. The sub-inspector, however, proceeded on leave on December 31, 1961 for a period of 9 days, ending January 8, 1961. After the sub-inspector returned from leave, he was directed by the court to produce the articles kept in the custody of the police under orders of the court. Thereupon, the sub-inspector opened the trunk on January 17, 1961, and to his utter dismay found that the trunk contained only stones and no articles, all of which had disappeared. The sub-inspector immediately filed a complaint of a theft of the ornaments, being crime number so-and-so, which is exhibit 34 appearing at so-and-so. In this complaint, the value of the property is shown at rupees 10,050 and which may be rounded off to 10,000. As the accused were not traceable, a summary final report was submitted. The original charge sheet submitted by the police against the 5 accused proceeded to its logical end, resulting in conviction of the accused by the trial court and in the unsuccessful appeal to the session judge Dharwar. The High Court in revision, however, acquitted the accused on technical grounds. After the conclusion of the trial, the complainant filed an application before the trial magistrate for return of the stolen property, or in the absence of the same, for payment of equivalent value thereof. This application was rejected by the magistrate on the ground that as the articles never reached the custody of the court, the complainant was not entitled to their restoration. The complainant then filed appeal to the session judge Tharwar, which also met with the same fate. Thereafter, the complainant went up to revision in the High Court of Mysore, which was also dismissed by the High Court mainly on the ground that the articles had not been placed in the custody of the court, provided provisions of the Code of CRPC 1898. They are hereafter referred to as the code. Has no application. The appellant prayed for leave to appeal to the Supreme Court against an order of the High Court, which having been refused, the appellant obtained special leave from this court and hence this appeal. It was in the context of the earlier CRPC. It was upon the conclusion of the trial. It is basically 452 as of today. It stands, my lord. In that judgment, paragraph 4, it says, the object and scheme of the various provisions of the code appear to be that where the property which has been subject matter of an offence is seized by the police is ought not to be retained in the custody of the court or the police for a longer period time than what is absolutely necessary. As the seizure of property by the police amounts to a clear entrustment of property to a government servant, the idea is that the property should be restored to the original owner after the necessity to retain it ceases. It is manifest that there are 2 stages when the property may be returned to the owner. In the first place, it may be returned during an inquiry and trial. This may particularly be necessary where the property concerned is subject to speedy and natural decay. There may be other compelling reasons also which may justify the disposal of the property to the owner and otherwise in the interest of justice. That other compelling reason, my lord, is well taken care of in proviso to 103 and 459.
No,
The High Court
in this para 4, it has spoken of only one reason. 2 stages when the property may be returned to the other. In the first place, it may be returned during the inquiry or trial.
Exactly.
What is the second stage?
Second stage is the, my lord, compelling reason.
Where does it say that?
This may particularly, there may be other compelling reason also which may justify the disposal of the property to the owner or otherwise in the interest of justice. That is, my lord, that speedy decay, my lord. The properties that are subject to,
I don't know. That is.
and it was in the context of, my lord, earlier CRPC.
You are implying that, but I do not know if that is the.
My lord,
We do not know. That has not been
that's
spelled out in so many
not
words.
specifically mentioned, my lord.
Then-
That is true. But, my lord, it was in the context of the earlier CRPC. This was, my lord, relied upon.
This is not in the context of the earlier CRPC, is it? How can it be? CRPC came about in 73.
My lord, this incident, my lord, I'm saying.
This incident might have been done, but then this
It
judgment
is
was
mentioned
passed in 1977.
My lord will kindly see paragraph 2, last part, my lord.
I have to, yes.
The sentence starting with the word around 7 lines from bottom of the paragraph, my lord.
Yeah.
Thereafter, complainant went up in revision to the High Court of Mysore, which was also dismissed by the High Court mainly on the ground that as the articles had not been placed in the custody of
Okay.
the court, provisions of the Code of Procedure 1898. This was relied upon in
So
1970.
if it was 1898, that 103, that is not there
that is
also.
not
Speed
there.
and so when it talks about 2 stages here, it
2
doesn't
stages,
talk.
my-
It doesn't talk about decay.
2 stages, my lord. Therein, my lord, it was there 516A and 517.
So does it talk about speedy decay? The old code?
516 SA, when any property which when any property regarding which an offense appear to have been committed or which appears to have been used for the commission of any offense is produced before any criminal court during an inquiry and trial, the court may make such order as it thinks fit for the proper custody of such property pending conclusion of the inquiry and trial. And if the property is subject to speedy and natural decay, he may, after recording such evidence as it thinks necessary, order it to be sold and otherwise disposed. If it is in 116A itself, my lord,
But this is with regard to 451.
451 and 459 were both there, my lord. In 516A, both were there because property which are subject to natural and speedy decay were also taken care of, my lord, in 516 itself. No, 523. Law Commission to Panama. So this 1978 judgment, which they are relying upon, my lord, is based on this judgment, my lord.
At the bottom, at the lower part, it might have been. But what do you say about the first two paragraphs? The second paragraph, when it says,
My lord, for that, my lord, I would like to rely on a judgment, my lord, 2000 volume 5, my lord.
because if I remember correctly,
2000 volume 5 SCC
just a minute,
488.
just a minute,
Yeah, it's in a copy, my lord.
page 52,
78 out of this.
at para 3 of the
Yes, ma'am.
judgment,
Section 457 covers the facts of the present case. The fact of the present case, my lord, that case. The police have recovered a considerable sum of money from the appellant and the money is stated to be seized in connection with an offense registered against the accused person, namely Bansilal, Sri Bansilal. Whether the appellant himself will be a witness or an accused is not possible to state at the present moment according to the counsel for the state. Be that as it may, the situation is squarely covered by section 457 CRPC. However, the fact that the court has the power to dispose of property by the police but not to produce seized by the police but not yet produced by the court does not mean that the special court judge must always release such property to the person from whom the property has been recovered, especially when the stage is of suspicion, that is investigation. The investigation is not over, charge sheet is not yet to be filed. So it also says, my lord, it was allowed during the stage of suspicion or investigation, but it says it cannot be automatically granted. And secondly, my lord,
but it
there is no issue.
automatically does not mean that it cannot be granted.
There was, my lord, no issue frame regarding. There is no issue frame, like whether, my lord, the section 457 also covers the stage of investigation and there is no ratio to that effect, my lord. This was not gone into to that length, my lord. 2002 volume 5 SCC, my lord. 2002 volume 5 SCC 488.
You see, if you come to para 4 of that same judgment, 1978 judgment.
Yes, my lord. In the present case.
No, yes, you come to the 5th line. All that we need do at the moment
is to uphold the power of the court to release property and direct the special judge to hold an investigation into the necessity of the note seized to be retained with the police in the court or in the court for future use at the time of inquiry or trial. On facts, my lord, it was.
If he is of the opinion that the notes are so required that property shall not be released.
Yes.
So what is saying that it depends upon the opinion of the court.
on a given fact, my lord.
Naturally, but during investigation.
But yes,
Because
on facts,
the-
my lord.
the- Yes.
On facts, this is a case wherein, my lord, during investigation, custody was granted. Was directed to be considered for grant of custody, my lord. But, my lord, in this case, there is no adjudication as to whether investigation is included in 451, 457. It was allowed on facts, my lord. This is
Allowed on fact, so what does it mean?
so. What will be its binding precedent, binding nature on other cases, my lord. That for that, my lord, 2000 volume
Yes.
5 SCC. 2000 volume 5 SCC 488, my lord.
2005,
2000 volume 5
2000 volume 5,
SCC 488 paragraph would be 20,
paragraph 20.
my lord.
You given me?
Yes, ma'am.
Okay.
I'll give compilation, my lord, after that.
I think you should, otherwise
Yes,
we are going to be, and with the index.
True,
Otherwise,
ma'am.
we are
I'll
going
give
to
a-
be looking here
I'll
and
give an
there.
index with page number and, my lord, all the documents, my lord, in a compilation.
Or I don't know, might be, this will be enough of the binding nature at para 20.
Para 20, page 488, it starts, the page will be 498. A decision not expressed, not accompanied by reason, and not preceding on a conscious consideration of an issue cannot be deemed to be a law declared to have a binding effect as is contemplated by Article 141. That which has escaped in the judgment is not the ratio decidendi. It is the rule of sub silentio, the technical sense, in the technical sense, when a particular point of law was not consciously determined.
Can I say that to the Supreme
Because
Court? Yeah.
Supreme Court has said so and said this also, madam. Honorable Supreme
And I
Court
will see.
says in 77 it has held that, my lord, in 2000 volume 5 also held this on, my lord. Sorry, 2000 volume 7. My lord, from the very beginning, my lord, I am contending in 1973 CRPC, my lord, why it has been incorporated. The word, these words, my lord, if are of no use, my lord, would not have been used. It's not a word, my lord, it's a sentence. And whenever the 457 for a moment, my lord,
Yes.
whenever the seizure of a property by a police officer is reported to a magistrate under the provisions of this code, on condition precedent. Second, starts with the word and. Such property is not produced before the criminal court during an inquiry or trial. This is the entire sentence will become redundant. Madam. Entire sentence. The word used during itself says something is in continuation, madam. During means in a particular period of time, something is in continuation. I have also got the definition of during. I think, madam, that will not be required. During something that is in continuation, madam. You know, the word violation is calculated.
Anything else?
Yes, well, 2000.
How much more minutes will you take?
Well, I'll just show one paragraph of five.
My
six
sister got a single bench also. And she has got one division bench. That division bench is just a judgment, but.
half an hour for tomorrow, my lord. Half an hour for tomorrow.
Tomorrow I will not be here. I'm going out of station. I'll be coming back on Sunday.
Then, my lord, within
Sunday.
10 minutes, I'll conclude, my lord. Whatever is convenient for your lordship, my lord.
Okay, you conclude. 10 minutes.
That's an added pressure, my lord, on me. Imposed by myself, my lord.
Ah, yeah.
2007 volume 8 SCC, man.
2007.
2007 volume 8 SCC 593 para 13.
Page
593. 2007, volume 8, 593, para 13.
1-3.
Yes, madam. 1-3, madam, at page 598. The problem can be, paragraph 30, the problem can be looked from another angle. If the view taken by the High Court that the provision is directed is accepted as correct, it would amount to making a provision of subsection clause C of the statute 6164 OTOs. In such a case, the consequences provided therein that if no opinion is exercised within the prescribed time limit, option is exercised within the prescribed time limit, the employee shall be deemed to have opted for the retention of the benefits already received by him would never come into play. It is well settled principle of interpretation of the statute that it is incumbent upon the court to avoid a construction if reasonably permissible on the language, which will render a part of the statute devoid of any meaning or application. The court always presumes that the legislature inserted every part thereof for a purpose and the legislature intended every part of the statute should have effect. The legislature is deemed not to waste its words or to say anything in vain, and a construction which attributes redundancy to the legislation will not be accepted except for compelling reasons. It is not a sound principle of construction to brush aside words in a statute as is being in opposite surpluses if they can have appropriate application in the circumstances conceivable within the contemplation of the statute. So this sentence, my lord, has to go then. Entire sentence will go, my lord, if we insert.
If we take it out, you mean.
Take it.
So basically, you are saying that if the statute is unambiguous, then the scope of interpretation dwindles.
Exactly. And my lord may not like to take out a word from the statute or insert a word like investigation in the statute, ma'am. That may not be the correct, my lord, rule of construction, my lord.
Anything else?
Well, on the same point, there are two
Are you
judges.
all taking time? You all are going to also. No more.
No more, my lord. I'll just answer to your lordship's two questions. I'm
Oh.
just waiting for that. That I will hardly take 2 minutes.
He has covered everything.
I will hardly take 2 minutes. I'll just answer your lordship.
No, you see, my sister got bench.
Bench, I know.
If your lordship is hearing it on, if your lordship is further hearing it, then okay, I'll rebut.
My
it.
lord,
But my lord,
give us
I-
a date, my lord, because certain other things, my lord, I need will be helpful for education, my lord.
You said 10 minutes, we'll give you 10
But
minutes.
time is being spent.
No. You can complete yourself. I'll take 2 minutes. 2 minutes means 2 minutes. I'll just answer to the specific question put by your lordship. Answer.
I'll be back on.
We'll be back on
Now thereafter we can continue then.
20 is Monday.
No, on 20 minutes today.
The problem with this bench be there. If you're not there.
My lord, give us a date, my lord. Everybody will have a smooth finishing, my lord.
You see, the problem is my sister is going to Bhopal tomorrow.
Okay.
And next week she's sitting in Arunachal. She'll be coming back after that. I'll be here.
Then next
But
to next week, my lord.
So then we'll have to constitute a bench again, I guess. Now, if I say Pathar, the problem that will crop up is that now we'll have to again be, sitting in this bench, which might cause problem. I don't know. So, okay, we can, but how long will it take?
I have to rely upon only 4 judgments, 4 paragraphs, my lord.
Okay, you give me, but you make it a compilation. with the thing, index.
Then, my lord, I'll just give the citations now, my lord, and
yes.
I will give a compilation later. on.
Yes,
That will,
give me a citation.
one will be, my lord, 2010 SCC,
2020,
volume 10 SCC,
10 SCC,
120,
120,
para 3.21.
3.21.
It is, then, my lord,
On
19
what aspect?
on 457, my lord.
457. Then,
Regarding investigation and inquiry stage, like that. Then 1993 supplementary 4 SCC,
1993,
Supplement-
supply 4
SCC,
SCC,
page 500,
500,
paragraph 15,
15. On what aspect?
on construction, my lord.
Construction of the statute.
Status, my lord. Then, my lord, 2005,
2005,
2 SCC,
2 SCC,
271,
271,
para 16 on construction, my lord.
16. Construction.
And there are 2 judgments of, my lord, Honorable on the High Court of Andhra Pradesh and Mumbai.
Now you from four four
Oh,
citations. you want to find.
these two are final, my lord.
Okay. On the same point.
Same, not same point, my lord. On the issue of, my lord, 523 of earlier code and, my lord, 457 of present code, my lord. The citations are very difficult, my lord. One is, my lord, 1970.
1970.
It's
Criminal Law Journal.
Criminal Law Journal,
1416.
Criminal law.
CRLJ 1461.
1461.
Party's name will be relevant, my lord. It is Balaji versus State of Andhra Pradesh.
Balaji.
And, my lord, the other one is 2003 0 AIIMR criminal.
Zero.
Yes, my lord.
Zero.
AIIMR
AIIMR.
criminal CRL 878.
878.
878. Cool. CRI, my lord, not L.
CRI.
Yes, but it is Nur Khan, Jafar Khan versus
Nur Khan.
Jafar Khan.
Jafar Khan.
versus SK Zakir SK Akbar.
SK. Ja.
JAKWR.
JAK.
WR.
Double ER. Zakir.
SK Akbar.
SK Akbar.
My lord, in my compilation, I will incorporate all these judgments, all printouts, my lord.
Now, on what aspect? Which paras in this one? These two cases. In Balaji, what is the
My
para?
lord, there are no paragraphs numbered, my lord. Small judgment with 3
No,
pages.
on what is the issue?
Comparison between
My lord, there was a comparison between, my lord, the 457 and 523, and it has been held, my lord, consciously
457 and
523 earlier code, and it has been held, my lord, it was consciously done. The investigation gets excluded, my lord,
excluded.
which was earlier silent. Earlier, at any time, the magistrate could have passed an order of custody, my lord.
In both the cases.
Both the cases.
Yes.
My lord, the pointed question which your lordship has asked, my lord, the lordship has put 3 questions.
Have I?
Yes, my lord. One is that whether the court will be denuded with the power of giving custody, then your lordship says, what about 226, my lord? Because they may have an alternative remedy under 226 or 482. So it is not that, if I have correctly understood your lordship, my lord, so your lordship is sitting, it is not that the citizens will have no remedy. They have remedy under 226 or 482. If your lordship holds that under 457, it is not required. My lord, I'll answer this question with an example, my lord. Now, my lord, there is a district in, my lord, with an example, the example will answer the question. There is a district in Assam called as Sodia. Now, my lord, Sodia, the distance between Sodia and Guwahati is 14 hours. Now, my lord, there are villages which are 10 kilometers from the Sodia stations. Now, my lord, if there is a particular person who every day morning he takes his vegetables from his field, he comes with his bicycle to the market and sells the vegetables and earns his livelihood, and evening he goes back to his village. Now, my lord, if that bicycle of that gentleman is stolen and the thief who has stolen that bicycle commits a crime, and that bicycle is seized as a property of crime, my lord. Now, my lord, to get Jimma of that vehicle, will I advise that man that you come from that village to travel to Guwahati to file a petition under 226 or 482, because 482 is also inherent jurisdiction of the High Court, or under 226. My lord, that would create, that would
You
absolutely.
see, that is with regard to a hardship that a person
My
might
lord,
face.
My lord, that is,
That is not the issue here.
my lord, that,
You see, we are not here to legislate.
my lord,
We are only here to interpret.
because my lord, the same 523 has been interpreted in the in a
I know
division-
why you are saying that, because you are talking about that, you are reminded of that milk van case.
milk van case, and moreover, my lord, because he has a criminal court at a handshake distance in his own district. Now, my lord, that is
No,
precisely.
that is the different.
Now,
thing.
my
You see,
lord,
that is
and
a
then
different aspect.
constitutional courts will be flooded with petitions under 226 regarding Jimma.
Or maybe,
Yes.
or maybe the legislature has consciously done this so that they whittle down the powers of the courts, so that the executive gets more power.
Now, my lord, that would again, my lord, it is very difficult to, I'm just putting
You
forth my
see,
point.
no, you see, that could be another reason.
That would give rise to police corruption if the
How do you
contemporary.
know?
Now, my lord, because my lord, an interpretation of it, because the learned friend, what he's, the rules of construction which he is relying on are the strict rule of construction, that if the meaning is. Now, my lord, if the strict rule of construction leads to an absurdity, or if it leads to a greater difficulty, my lord, then it can be deviated from. In fact, my lord, 523, because that provision under the old Act 523, which has now been enacted as 457, that has been clarified by the division bench of, because one of the judgments which I relied, page.
You said 2 minutes already, I think.
No, my lord,
you-
because
you-
that
you-
question-
1 minute 45 seconds gone. You've got another 15
No, my
seconds.
lord, otherwise, my lord, because I'll be failing in my duty. if I don't-
No, you give us the right time. Don't ask for 2 minutes and start for 20 minutes. or something.
So your lordship will not be sitting in this, for this matter, today.
So next week, though, we cannot sit together.
They have to, he will be happy if I don't debate, that's a different issue.
We'll file a written.
So, because he's opposing my, I'm asking the leave of the court, my lord. So, my lord, if your lordship sits after that week, my lord, because, my lord, some rebuttal, because he has taken much time in this construction of statutes and everything, my lord, some rebuttal is required. Because from
I thought you
CRPC,
said 2 minutes was required.
my lord, 2 minutes only on the factual situation, because 226 will not be a appropriate remedy in this case.
Okay, we'll give you time, then we can fix a date.
Absolutely, my lord, we'll fix a date, my lord.
But then I think what you have stated I mean, that's the basic. You all cannot go much beyond that.
Absolutely. Only on the rule of construction, whether this rule of construction will be applicable in the present scenario.
The argument that you're putting forth
Yes.
with regard to the hardships that would be caused, that is something, that is beyond the powers of this, beyond the powers of judicial review. That is something.
And moreover, my lord, this fact has also been, because this
Because
fact,
out here, we are only here to answer a reference on a limited question of fact, where we cannot go into those aspects.
my lord, the
We
phrase,
are not going into equity or anything.
my lord, the phrase that and not produced during inquiry or trial, quote unquote.
Yes.
That phrase, means and stage of investigation, is not what Mr. Biswas is submitting. It is what 2 honorable judges of Calcutta High Court have said. It is what 2 honorable judges of Rajasthan High Court have said. This is what 1 honorable judge of the Orissa High Court have said. This is what 1 honorable judge of the Madhya Pradesh High Court have said, that the word quote unquote, that and not produced during inquiry or trial in 457, these words, quote unquote, my lord, these words means a stage of investigation. So, my lord, this is not that this is something which I am propounding or I am trying to propose a line of interpretation. These are judicial pronouncement from the Honorable High Courts, which are also governed under the same constitution, my lord. And my lord, under 102, yes, the other question which the lordship was asked, that under 102, there is a police power. My lord, I also, that is why I said, my lord, it will, if your lordship put one
We'll
way.
give you a date.
Absolutely, my lord, absolutely. We'll give you-
Otherwise,
absolutely. I also don't feel good, my lord, to insist court when the court is
No,
about
you're
to
not going
rise.
to complete it anyway. Even if we give you another 20 minutes, I'm quite sure you're not going to complete.
Lordship will give us. But I will try, my lord.
Okay, right. Heard Mr. P.N. Goswami, learned additional AG. Also heard Mr. M.
Biswas,
Biswas and Mr.
Z Kamar.
Z. Kama,
Assisted by Dhingia.
assisted by Mr.
As the Indian.
SD and Mr. Assisted by
A.K. Gupta.
A.K. Gupta. Learned counsels for the respondents. The matter be listed again on when, madam? When? 21.
21st of February.
21 2.
I'm diplomat.
Yes,
Madam, may indicate it is part heard, madam.
let the matter so as part heard. Huh?
Yes, sir. Obliged.
Just a minute, let me just put all these papers. Thank you for giving us so much homework.
The next date might appear only to be the tip of the iceberg. I gave compilation.
Okay, this is different.
Deeply obliged.
This is also.